Matters have been disposed of. Reached final appeal apex court. These are connected matters because of the
Is that a land acquisition matter? Told me Monday could Monday or Tuesday. No,
My lord, in this matter, I'm respondent number 6.
right.
The interim order was not extended because the petitioner did not appear on a particular date. Later, when the matter was listed again, the interim order, which was earlier vacated, was extended again. In that connection, we're trying to move this matter for Monday, Your Honor.
Yes.
Your Honor, my lord, another matter. I'm the petitioner in this matter. BDA has allotted a land to me, subject to all the conditions fulfilled by me. And now the
Is fresh
Forest
matter?
Department.
Is that a
This is
fresh
a pending
matter?
matter, Your Honor.
I told you. Which year?
Of 2025.
Told you.
Maybe kindly be had tomorrow.
Hmm.
Obliged.
Monday, Tuesday. What? Acquisition matter. I told you. Good. Tuesday. Told. Yes, correct. Adjournments.
Adjournments. Adjournments page wise. Page number 5, serial number 18 to 23. Page number 6, serial number 24 to 31.
My lord, serial number 24.
20?
24, my lord.
Yes.
Appearing on behalf of Mr. K.S. Mahadeva, the advocate for the petitioner.
Ah.
Had a personal inconvenience, my lord.
Why don't you argue the matter?
My lord, he's
You're Mr. Mahadevan's colleague.
Yes, ma'am. Yes, ma'am.
Why don't you argue the matter?
My lord, there's a slight personal inconvenience. It may be taken up anytime next
So
week.
can you not argue the matter?
No, my lord, I don't have the file.
You don't have the file. Please take our court file and argue. It's a very simple matter, madam.
My lord, I understand. It may be taken up any day next week.
No, why don't you argue? Put your file. Please take the court file, read the file, come back.
But I'm not a part of his. I'm not his colleague.
Huh?
I'm not his office colleague. I'm one of the other panel actor, one of the other advocates who was asked to take an adjournment because he had a personal inconvenience.
And counsel for the petition seeks time. List on date. Could
Tuesday, 9th June.
On Monday, my
9th June. Page number 7, serial number 32. Page number 8, serial number 33 and 34. Page number 9.
30? 2015 case. Huh? ಹುಷಾರಿಲ್ಲ ಅಂದ್ರೆ ಯಾರಿಗೆ ಯಾರು ಅಜಯ್ ಅಲ್ಪ ಯಾರು serial number 34 is Karthik. serial number 34 34 ಅಜಯ್ ಅಂತ ಯಾರು ಇಲ್ವಲ್ಲ ಯಾವ ಕೋರ್ಟು 44 ಅಲ್ಲ
Page number 9, serial number 35 to the 40.
35.
Huh?
Rohini came. Rohini, the petitioner counsel.
Madam, these are all old matters. I don't know why lawyers do not. 2016 petition. What is? How are you justified in asking for an adjournment when the matter is listed for final hearing? 2016, 14, 13. No, it reflects poorly on the advocates more than the judges. It reflects poorly on the advocates. Hale matter list agide, you should be happy that your matters are listed. Learned counsel for the petitioner seeks time as the last since the petition is filed in the year 2016. The request for adjournment is not justified. Nonetheless, as a last chance list on so and so made clear, no adjournment shall be granted on the next date of hearing.
11th June. 11th June. 11th June.
Learned counsel for the petitioner seeks time. Same order. List on so and so. 58. In ಎರಡು matter they are ತಗೊಂಬಿಡಿ adjournment ತಗೊಂಬಿಡಿ. No, final hearing there are only about 8 or 10 matters. 4 matters are already adjourned. In R ಇದೆ ಅದು ತಕೊಂಬಿಡಿ ಅಂತ ಹೇಳೋದು. ಯಾವುದು serial number? Learn counsel for the petitioner seeks time, list on sounds, same order.
16.
Only 10 matters are listed for final hearing.
Page number 10, serial number 41 to 46.
44.
ನಾಗರಾಜ್ ಹೆಗಡೆ, ಮಮತಾ, ಕೃಷ್ಣ, ನೀವು ಯಾರು ಇದರಲ್ಲಿ? ನಾಗರಾಜ್ ಹೆಗಡೆ. 43 and 44. Learn counsel for the petitioner seeks time, same order. List along with WP number 38216 of 2017. That's serial number 43, that's adjourned. Yes.
Page number 11, serial number 47 to 50.
Same order. No, but from next week onwards, I am going to impose cost of 5,000 rupees. I'm just warning all lawyers, for every adjournment in final hearing matters, I am going to impose cost of 5,000. Yes, next.
Page number 12, serial number 51 to 55.
It's 52 my lords. Next Monday ತಗೊಳ್ಳಿ my lords.
52.
Monday my lords ಅದು ಅರ್ಜೆನ್ಸಿ ಇತ್ತು ಲಾಸ್ಟ್ ಟೈಮ್ ಮೆನ್ಷನ್ ಮಾಡಿದ್ವಿ my lords. ನಾವು ಸೈಟ್ ಪರ್ಚೇಸರ್ BDA ಇಂದ.
Learn counsel for the petition seeks time, same order. List on so and so.
Page number 13, serial number 56 to 63.
Serial number 59, my lords. Lords, I'm for the petitioner in this matter. My lords, due to some family urgency, my senior is not able to attend.
Same order.
Millards 57 Millards are appear for petition.
Hmm.
Millards 2 weeks
Same
time.
order.
Interim order may be extended.
Interim order is extended to the next date. Yes.
List number.
Acquisition. Land acquisition matter. ತಗೊಳ್ಳಿ ಯಾವ ಡೇಟ್ ಕೊಡಿ.
List number 1 for non-compliance second time, serial number 1.
Lord, I appear for the petitioner. Lord, the office objection, my lord, is that all the advocates have not signed the wakalat. My lord, matter pertains to PRR. Lord,
Fine it.
maybe
1 week to the next.
pass over ಮಾಡ್ರಿ, ಇವತ್ತೇ ಮಾಡ್ಸಿ.
March there.
Or kindly pass over.
Mr. Dev, PR.
My lord, I appear on behalf of the petitioner, my lord. My lord, the office objection, first objection, my lord, is that the jurisdiction to be stated correctly, it should be 226, my lord, and not 227. We will have it corrected, my lord, that's not an issue. And then so far as second one, my lord, is concerned, the petitioner, my lord, is a trust. And that they want it to be stated in the cost title, though it has been stated in the petition. We will do that.
What are these office objections?
My lord, the first office
Petitioner
objection,
is. You
petitioner.
Please ask the advocate and record to comply these office objections. You do not know whether the petition is a trust.
My lord, we have said so in the
Trust,
petition.
It's not mentioned in the cost title.
We will mention
Please
it.
comply, ask him to come.
Yes, we
1
will do
week
that.
time is granted to do the needful.
Can I just, your lordship, what the point, my lord, is in fact, I don't need any interim order. All that I need is a notice, my lord.
No, but this office objections have to be complied. Please comply. I'll issue a notice, but in the meanwhile, you please comply.
Yes, great, we will do that. Yes, great. We'll do it today. Today itself will be done.
I take notice for R2.
Murugesh Charati is directed to accept notice for respondent number 1, AGA for R2. In the meanwhile, the learned counsel for the petitioner is directed to amend comply the office objections. Yes.
Great, very great.
For orders matter, serial number Tilak Raj SV.
That's memo for retirement filed by the previous council, my lords. My name is shown, my lords. The previous council name may be deleted, my lord.
The memo for retirement filed by the early, filed by whom?
The previous council,
Mr. H.N. Basavaraj
HN Basavaraj.
is allowed. Office is directed to delete his name from the causes and continue the name of Mr. Tilak Raj
Please,
S.V.
ma'am.
Yes.
Date may be fixed, my lord.
Yavat.
Next Tuesday, my lord.
Sorry. List the petition for preliminary hearing in B group on Thursday, 11th June.
Grateful.
It is made clear that no adjournment shall be granted on the next date of hearing.
Serial number 4, Dinesh Gonkar.
Dinesh Kaunkar, pass over.
Postal Sera, no such person.
Process Katli Yaradu. Let them show some progress.
Serial number 5, Venkatesh TS.
Installation of sewage treatment plant filed by advocate.
Your Lordship, in this case, by the order dated 8/9/2023, it was directed for the fourth respondent to furnish the cost of the STP.
Yeah, who appears for fourth respondent?
I appear for respondent number 4, my lords. We have furnished a memo, my lords, 27/3/2024.
Yes.
Your Lordship, BDA has produced the cost of, BDA has stated the cost as 1,42 lakhs, Your Lordship. But on the contrary, fourth respondent had showed the cost of STP is only 30 lakhs, Your Lordship. Your Lordship, in this case.
Who is fourth respondent?
Society, Your Lordship.
Society in the society.
Kanakashri Graha Nirmana Sahakara Sangha.
Who is the petitioner then?
That is welfare, residents and welfare association, Your Lordship. This is welfare association. This fourth is society which formed a layout in this particular land, Your Lordship. In this.
What is the total extent of land?
62 acres, Your Lordship.
You don't have an STP?
No STP, Your Lordship. As per the work, they have to provide the STP.
Who has to provide?
Fourth respondent, Your Lordship. Fourth, but in the order dated 8/9/23, they stated that since there is only 30% occupation, so they cannot install the STP. That's what they submitted on the 8/9/23, Your Lordship. For that, the Honorable Court suggested, if the sufficient, this one is not there, you please deposit the money. That's what in the previous occasion suggested, Your Lordship. It was in 23. Now nearly 60 to 70% occupation is there, Your Lordship, as of now. If they install the STP, it's well and good, Your Lordship. Or else they have for the cost.
You have for respondent number 4.
Malas 30 lakhs, malas we have given a memo, malas 30 lakhs it will cost, malas we are willing to deposit or pay 30 lakhs.
30 lakhs al yenagutte?
If it's more than that, I'll have to take instruction because we have deposited, we have given a memo, malas. Even we have
No,
taken the
what,
sank.
can you have a STP for just 30 lakhs?
800 sites,
in fact, malas,
800 sites.
In fact, malas, we had paid for sanction of the STP, malas 20 lakhs was already paid by us, malas. Now, malas,
to whom have you paid?
malas, it's recorded in the order sheet itself, malas.
No, Pollution Control Board, at the time of taking permission, they have deposited in the Pollution Control Board. That's what they say.
Towards what?
Towards for putting up the STP. That's what they have filed. They say.
To secure permission to set up STP, malas.
Permission to set up STP, we do not know whether that is some fees or some charges.
30 lakhs we willing to, if it's more than that, I'll just verify, malas, because it's come up to 1.4 crores, malas.
BDA says it is 1.4
1.4 crores, malas.
1.42 crores.
Malas, I'll take instructions, malas, 30
Since
lakhs
there was
is
a
our
dilemma
capacity.
with reference to the total cost, my lords, the honorable court has directed the BD officials to go and inspect at what are the total costs and produce a report. But I have produced a report, my lord, it comes to 1,42 lakhs.
Please, malas, our capacity, malas, 30 lakhs, but more than that, malas, whatever we can, I'll take instructions, malas. Because the memo is filed to that effect.
Is that a tertiary treatment plant or what? Tertiary or secondary?
Secondary. They are not yet installed, Your Lord.
Correct, but 1.34 crores is towards a tertiary plant or for a secondary water treatment plant?
I'm not aware of technical.
MBBR technology.
Correct, then tertiary ga, secondary ga, yenadu. Tertiary is virtually removing all impurities.
Correct.
Removing everything and discharging. Secondary is only to a certain level.
No, first one, Your Lordship. What Your Lordship said, first one.
Secondary.
First one.
For tertiary.
For yella clean madbekittu. Your Lordship, they have given the list also. What are they have going to install?
Yes, when will you get instructions?
Malas, a week's time may be given, malas. If 30 lakhs we're willing to, malas, anything more than that, I'll just seek instructions.
Actually, the matter was referred to mediation also to get them settled.
Barkul, the Learned counsel for the respondent number
make
2
one submission.
has filed a memo stating that the cost of installation of a sewage treatment plant as estimated by Yaro,
By respondent number 4 is 30 lakhs. By respondent number 2,
who has
Assistant
estimated it?
Assistant Executive Engineer,
As estimated by the Assistant Executive Engineer of
North Division, BDA,
of
second respondent.
as estimated by its Assistant Executive Engineer is a sum of rupees 1 crore 34 lakhs,
42 lakhs.
42 lakhs.
1 crore 42 lakhs. However, the cost of the STP as assessed by the respondent number 4 is a sum of rupees
30 lakhs.
30 lakhs.
Please.
Full stop. The learned counsel for the respondent number 4 therefore seeks time to secure instructions whether a sum of rupees 1 crore 44 lakhs could be deposited so that the same could be utilized by the Plot Owners Welfare Association for the establishment of an STP. Is yavat list down on date?
A week's time may be given.
12th June.
Please.
Serial number 6 on the plant, DM.
Let's serial number 6, I appear for the petition. Finally, 2 days time you granted to take steps. Let's party.
This 2024 in India idiyalla.
Let's party instruction ಕೊಡ್ತಿಲ್ಲ ಅದಕ್ಕೆ.
Mr. From November
Final 2 days
2024 you have not taken process.
My finally 2 days I will get instruction in party.
No, not justified. Learned counsel for the petitioner seeks time. List on Monday.
Serial number 7, G1K.
Therefore, the petitioner has received the copy of the statement of objection.
Learned counsel for the petitioner acknowledges the receipt of the copy of the statement of objections. His office objections raised on the statement of objections is overruled.
It can be taken up on week after next mailer.
Why?
Because
Why not today?
I am not ready because several.
You're not ready?
Today I am not ready.
It's a rival claim by the same side by the two respondent to two and the petitioner. Whether both of them claiming as the revenue sites. The first, the petitioner claims my lord, he is a member of the Bapuji and Atiguppe Association. And second respondent claim that he is the allottee of the site from the Kalyana Cooperative Society. Both are claiming as a revenue sites. Now, my lord, the earlier one, there is a suit is pending between the second respondent and the petitioner before the civil court regarding title. BDA issued the endorsement, my lord, after the decision of the trial court, the issuance of the sale deed will be proceeded further. That was challenged in the petition.
Yes, Mr. How is the petition maintainable?
No, my lord, because it is several round of litigations in this.
Please use the mic.
Actually, there is several round of litigations in this matter before this honorable court, even in the WP also. That is.
No, if both of you are claiming the same site.
Yes, madam.
And the matter is pending before the civil court.
Yes, actually.
How can the BDA allot the site to one of you?
Actually, what happened in this case regarding that earlier petitions, this honorable court has clearly directed the BDA to execute the sale deed in that particular site in our favor, madam. And later, when they didn't do that, we filed a contempt. In the contempt, they taken the contention that since that OS is pending before the, but actually the
You bring to the notice of this court when the earlier order was passed that a civil suit was pending?
Yes, madam. They filed the review also. In the review also.
Where is the earlier order?
Earlier, that similar order that is in.
Earlier order is
page number 32, my lord. That is filed by the similarly placed petitioners, and on that basis we have also filed the writ petition. And in that petitions, this honorable court has clearly
discussed. In the earlier writ petition, you are not a party.
But later we have 3841 with that one. Recent writ petition, that is at page number 168, my lord.
ಏನಂತಾಗಿದೆ?
To execute the sale deed in favor of.
ಇಲ್ಲಿದೆ ಓದಿ.
That last parallel.
ಓದಿ, please read.
The BDA respondent BDA is directed to consider representation dated 12/1/2002 with regard to execution of absolute sale deed in respect of site bearing number 725, more fully described in the schedule to the writ petition, and pass appropriate order in accordance with the law within a period of 3 months from the date of receipt of a copy of this order.
And earlier also there is one order, and but there is no period
Correct.
stipulated.
Where is the direction that sale deed has to be executed in
That is
your
in the-
name?
That is in the earlier order, but
Please read paragraph number 6 of that order.
yes. The rival claimant, it is to be taken note of that the suit in OS 7984 of 11, as stated by the learning counsel by the petitioner, is pending with regard to rival claim in respect of the same site, scheduled site. The rival claimant can have filed review petition 567 of 11 praying to review the order dated 29/7/2011 in 23692 of 2011. While disposing of the review petition, this court observed that the Bangalore Development Authority would apply its mind before execution of the sale deed with regard to the schedule mentioned in the writ petition. The representation submitted by the petitioner is pending and the same is not disposed of. The respondent BD has legal obligation to consider the said representative in the light of the order passed by the court in the above stated writ petition as review petition. Hence the following.
So civil court ತೀರ್ಮಾನ ಆದ್ಮೇಲೆ BD ಅವರು ಏನೋ decision
The court case filed by the respondent number 2 before the civil court is only regarding suit for injunction, my lord. It is not regarding the declaration or regarding the titlement. So because I have to highlight
where is the plaintiff in that suit?
that even the evidence also I have to produce that documents before this on. That's why I am seeking time.
Why do you produce documents which are not necessary?
Yes, earlier.
And you are not produce documents which are necessary.
Even BDA evidence is also recorded in that suit that I have to produce before this one. That's why I am saying.
BD ಅವರು ಕೊಟ್ಟದ್ದು ಏನಂತ ನೀವು ಸೂಟ್ ತೀರ್ಮಾನ ಆದ್ಮೇಲೆ ನಾವು ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
But
what is wrong in that?
But suit ಅಲ್ಲಿ because it is injunction suit, ಅದು question of identity and ಇದು ಮಾಡೋಕೆ ಬರೋದಿಲ್ಲ. ಅದರಿಂದಾಗಿ anyway I will produce that documents 1 week time, week after next any date.
Learned counsel for the petitioner is directed to place on record the plaint filed in OS number
7984 of 2011.
7984 of 2011. 2011. List on date good. Sharan Majge, a memo is filed, serial number 8. A memo is filed by the learned counsel for the petitioner to withdraw the writ petition. In view of the memo, the petition is dismissed as withdrawn. Yes. Liberty, yeah. You sought liberty?
Please, my lord.
For what?
If it is necessary in future, my lords.
In future, andre?
Plan
to see the future.
No, award has been passed, general award has been passed, that has been
So
challenged.
why you want to liberty?
Now they are saying that, my lord, matter may be resolved when the.
No, but you should mention why you need liberty, mister. You
Then-
simply say, if I feel like filing.
No, I will not press, my lord.
However, liberty sought for by the petitioner to file a fresh petition is rejected. Yes, next.
For hearing on IA serial number 9, Prakash RM. Hearing on IA serial number 9, Prakash RM.
IA 1/24 shall be considered along with the main petition. The list for
And for the respondent BD, I must appraise the court of one development, my lords. Writ appeal is pending over this order where review is allowed.
No, what? Review is filed by whom?
By the petitioner, my lords. Originally, writ petition is dismissed. Thereafter, review is filed. Review is allowed by order dated 5th of August 2025. ಅದಕ್ಕೆ restore ಆಗಿದೆ ಇದು.
So you have challenged it in.
Yes, my lords. That is coming up on 17th before the division bench, my lords. In stay ಅಂತ ಏನು ಕೊಟ್ಟಿಲ್ಲ, but I just.
ಆಯ್ತು, we'll consider this IA along with the main petition list for preliminary hearing in B group on when do you want it?
After 17th, my lords.
ಕೊಡಿ ಯಾವ್ದು?
19th.
Tejas SR.
Serial number 10. Tejas SR.
Application. May I just request the Honorable Court kindly turn to Annexure M, page 46 of the writ petition. The narrow compass of the petition is this.
Page 46.
46 annexure M. Lordship, this is a layout formed by the BDA in the early 2000s. After 20 years, at the bottom of this, the Honorable Court kindly notice, after 20 years, a site comes to be inserted in the middle of a row of 10 sites. I request Honorable Court kindly look at the bottom left portion. There's an endorsement saying site number 1329G1 has been incorporated. This the Honorable Court got. This is done on 19/10/2019. The Honorable Court may kindly go follow the arrow. It goes up to 18th May. The Honorable Court noticed there were 10 sites originally. After 20 years, the BDA in the middle of those 10 sites inserts the 11th site. All those people who are, and the Honorable Court also noticed behind there remain to be 10 sites. Now physically there is no space available there. The BDA comes after 20 years, inserts it, and now all the people who are located there are affected by this. And I challenge this insertion and file this writ petition.
This is numbered as G1.
G1. Now A2J is there in that row. In the middle of it, next to F and G, they insert G1 in the layout plan. Now physically there is no space available in the layout. They come to insert this, and what is more shocking is that even prior to this insertion, 6 months before to this, they've already sold that site G1 to somebody. Now that person I'm seeking to implead in these proceedings. Absolute fraud committed by the BDA. Now I am the owner of 1329F. When I go to construct a building pursuant to building sanction plan obtained from the BBMP, some
What is the
person.
measurement of your plot?
My plot is 30/40. The entire row is 30/40.
Then how could they incorporate a site where there's no space at all?
There's no space physically, and they've even sold this property even prior to insertion. 6 months prior, the BDA. The Honorable Court will kindly note this person has been.
My instructions. I've placed the statement of objections for signature. I'll file it in 2 days' time, my lords. My lords, there was space. 30/40 site.
How did you approve the plan then earlier?
My lords, reorganization anta madbiಟ್ಟು reorganization ಆಗಿ there was an extra site. ಅವ್ರು ಏನ್ ಮಾಡಿದ್ರು ಎಲ್ಲರೂ ಎರಡೆರಡಿ ಮೂವ್ ಮಾಡ್ಕೊಂಡು ಹೋಗಿದ್ರು ಮೈ ಲಾರ್ಡ್ಸ್. ಸೊ ಹಂಗಾಗಿ ಮೋರ್ ದೆನ್ 30/40 ಸೈಟ್ ಅಂದ್ರೆ 30/40 ಗಿಂತ 30/42 30/43 ಆತರ ಒಬ್ಬೊಬ್ಬರಿಗೆ ಹೆಚ್ಚಿಗೆ ಇತ್ತು ಮೈ ಲಾರ್ಡ್ಸ್. ಅದನ್ನ ನಾವು ಮತ್ತೆ ರೀಮೆಜರ್ ಮಾಡಿ we have now found out that there is an extra site that could be sold, my lords. So as such, only for the financial benefit of the organization, my lords, this site was inserted. My lords, I will place all those notifications and the survey sketch and everything on record.
ಮಾಡಿದ್ರು ಸೈಡ್ ಅಲ್ಲಿ ಮಾಡಬೇಕು, ಮಧ್ಯ ಬಂದು ಎಲ್ಲಾರನು ಡಿಸ್ಪ್ಲೇಸ್ ಮಾಡಿ ಇವಾಗ ಎಲ್ಲಾರ್ ಸೇಲ್ ಡೀಡು ಅಮೆಂಡ್ ಆಗಬೇಕು, ಎಲ್ಲಾರ್ದು ಶೆಡ್ಯೂಲ್ಸ್ ಅಮೆಂಡ್ ಮಾಡಬೇಕು, ಎಲ್ಲಾರ್ ಬೌಂಡರೀಸ್ ಅಮೆಂಡ್ ಮಾಡಬೇಕು. How is this even possible? And they have not taken any steps to do any of that. No notification to anybody.
Anyway, you can't be in possession of something bigger than what you are allotted.
Absolutely. If that is the case, that they are entitled to do. But they cannot today come without notice to anybody, without any reorganization, without amending the schedules, the boundaries. Now let them place all that on record. It's a 7-year-old case. I only request 2 days they're requesting. Any date may be fixed, short date. That's the narrow compass.
Who is this applicant in IA 1023?
He's the person who has now been allotted G1.
Notice ಹೋಗಿದ್ಯಾ?
Notice ಹೋಗಿದೆ, ವಕಾಲತ್ತು ಹಾಕಿ 2 years ಆಗಿದೆ ಸರ್. 24 ಅಲ್ಲೇ ವಕಾಲತ್ತು ಹಾಕಿದ್ದಾರೆ.
IA 1023 is filed by the petitioner to implead a subsequent allottee of a site bearing number 1329/G1 at BTM 4th stage, 2nd block, Bangalore. Stop. It is a case of the petitioner that during the pendency of this writ petition, the aforesaid site is allotted to the proposed respondent.
I apologize. The pendency allot agila. Allot is prior. We came to know about it after filing the writ petition.
That the petitioner came to know of the allotment of the aforesaid site to the proposed respondent, and therefore the proposed respondent is a proper and necessary party to this writ petition. The respondents 1 to 3 are the proposed respondent is served and has entered appearance to an advocate. However, no objections are filed to the application. Having regard to the fact that any order that may be passed in this writ petition would affect the interest of the proposed respondent, it is appropriate that the proposed respondent is not on record. Hence, IA 1023 is allowed and the proposed respondent is ordered to be brought on record as respondent number 4. Counsel for the petitioner is directed to amend the cause title.
Please.
Office is directed to show the name of the advocate representing the respondent number 4 in the cause list. It is open for the respondent number 4 to file a statement of objections.
Respondent number
Yes.
4.
ಇಲ್ವಾ? ಹಾಕಿಲ್ ವಕಾಲತ್ ಹಾಕಿಲ್ವಾ?
ಹಾಕಿದ್ದಾರೆ ಆನ್ಲೈನ್ ತೋರಿಸ್ತಾರೆ. ಇನ್ಕ್ಲೂಡಿಂಗ್ ಅಪ್ಲಿಕೆಂಟ್ ಹಾಕಿದ್ದಾರೆ ಅಂತ ಆನ್ಲೈನ್ ತೋರಿಸ್ತಾ ಇದೆ. January 24
ನೋಡಿ ಯಾರು ಅಡ್ವೊಕೇಟ್ ಯಾರು ನೋಡಿ?
ಆನ್ಲೈನ್ January 24 ಅಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ ಅಂತ ತೋರಿಸ್ತಾ ಇದೆ ಇನ್ಕ್ಲೂಡಿಂಗ್ ಅಪ್ಲಿಕೆಂಟ್.
ಚೆಕ್ ಮಾಡಿ. Yes, next.
A date may kindly be fixed.
Take whatever date you want. Yes.
Next Thursday.
24th, if I may request.
Karthikeyan, when can you
24th.
get instructions?
Yes, 24th.
24th. List on 24th ನೋಡ್ರಿ ಯಾವ ವಾರ?
ಬುಧವಾರ.
24th is Wednesday. 25th.
ಹಾಗೆ.
25th.
Great.
Serial number 11, Ajay JN.
Yes, what is this amendment?
My lords, seeking to add, my lords, idರಲ್ಲಿ I'm asked, ನನ್ನ sanction plan approve ಮಾಡುವಾಗ they took a certain portion of the property towards road. My lord, it's covered by my lord's judgment only. I'm just seeking to amend to bring on record two facts, my lord. There is already a communication by the BDA in relation to this matters, which I have produced at page number 13. Then, my lords, I'm seeking to add one additional prayer, saying that direct
objection.
My lord, the amendment is more than the writ petition pleadings.
That normally happens, Allah.
That's subject
You
to
realize only after the respondent appears and makes a statement. So the amendment application will normally be lengthier than the writ petition itself.
liberty to file the additional statement.
IA 125 is filed by the petitioner to amend the writ petition to incorporate further facts and further reliefs. Since the petition is still, since the petition is not yet admitted, the application deserves to be allowed, as no hardship or injury would be caused to the respondent. So in that view of the matter, IA 125 is allowed and the amendment sought for is permitted to be inserted in the writ petition. The learned counsel for the respondent number 2 and 3 is at liberty to file a statement of objections to the amended writ petition. Counsel for the petitioner is directed to amend the writ petition and also file an amended writ petition after serving a copy to the learned counsel for the respondents. To the learned counsel for the respondents. Yes.
Yes,
Serial number 12, Nagaraj, yes.
I'm appearing for the petitioners, Your Lordship. Your Lordship, we haven't received any application from them, Your Lordship.
What correction, Nenu?
Okay, for the respondent number 2, my
So what is the correction?
Only, para 8 in judgment, my lord. Para 8.
Para?
8, my lord.
Yen correction?
Therefore, last 3 lines. Therefore, order to protect the interests of the plaintiff pending disposal of the suit. It is the appropriate to direct the respondent number 2 to 4 aspects of mail.
To the direct the defendants, huh?
Yes, my lord. Defendants 2 to 4. Notice was not served in the writ petition, my lord. Notice respondent number 2 dispensed. ಇಲ್ಲಿ notice defendants 2 to 4 ಆಗಬೇಕು. Deposit a sum of rupees 1 lakh.
The notice to R2 was dispensed.
Yes, my lord.
Defense 2 to 4 yaar
2 to 4 in the
petitions are the defense 2 to 4, huh? You know.
ಹೌದು 2 to 4 ಆಗಬೇಕು ಸುಮ್ಮನೆ. In the para 9 last line ಅಲ್ಲಿ ಇದೆ.
Barcode. This application is moved by the learned counsel for the petitioners.
Respondent
number 2. Learned counsel for the respondent number 2 to correct the order dated 1st of September 2022. It is stated that in
last line, para 9 last line.
In para 13, line 13 of para 8 at page 5 of the order, instead of mentioning the defendants 2 to 4, it is mentioned as defendants.
Page 6, judgment page 6, my lord. The defendant number 2 to 4 shall continue to the deposit a set sum of rupees 1 lakh. ಅಲ್ಲಿ ಆಗುತ್ತೆ. 4th line.
ಇಲ್ಲಿ para?
ಮೇಲಿಂದ.
Para 6 ಅಲ್ಲ?
ಇಲ್ಲ, para 8 ಅಲ್ಲಿ last page 11 ಮೇಲೆ. Page 11.
The typed page 6.
6. Judgment page 6.
ಒಬ್ಬೊಬ್ರು ಹೇಳ್ತಾರೆ ತಡ್ರಿ, ಯಾರೋ ಒಬ್ರು ಹೇಳ್ರಿ.
4th line ಮೇಲೆ. Defendants 2 to 4
shall continue to deposit. Likewise in the 4th line at page 6. Instead of the words defendants, comma, it should be mentioned as defendants 2 to 4. Understand? Also, learned counsel for the petitioner. Petitioners has no objection to allow the application, correct the order as sought for. In that view of the matter, comma, IA 1 of 26 is allowed. And in line 11 of paragraph number 8 on page 5, instead of the words defendants, it shall be read as defendants 2 to 4. Likewise, in line 4 at page 6, the words defendants shall be read as defendants 2 to 4. This order shall be read in conjunction with the order dated 1/9/2022.
Serial number 30, Rajeshwar PN.
PN Rajeshwar.
LR application was filed in respect of respondent, deceased respondent number 5, my lords. Notice had been issued, they have filed their wakalat.
H.C. Sundaresh. Barful. IA 1 of 24 is filed for continuation of delay of 24 days in filing the application to bring the legal heirs of the deceased respondent number 5. A continued delay of 24 days in the cause shown for the delay is produced, and this court is satisfied that the petitioner could not file the application within time to bring the legal heirs of the deceased respondent number 5. Hence, IA 1 of 24 is allowed. And the delay of 24 days in filing the LR application is condoned. Why are you filing 3 applications when this court has said 1 application is enough?
It was in the.
Sorry, but 1 application is enough, mister.
Yes.
Just imagine 40,000 writ petitions. Everybody goes on filing 1 of 3 applications. IA 2 of 24 is filed for setting aside the abatement. Adonದು circular ಹಾಕ್ರಿ ಅಲ್ಲಿ ಇತ್ತಲ್ಲ ಎಲ್ಲಿದೆ ಅದು? ಅಡ್ವೊಕೇಟ್ ಕೊಟ್ಟಿರೋದು ಎಲ್ಲರಿಗೂ ಗೊತ್ತಾಗಂಗೆಲ್ಲ ಡಿಸ್ಪ್ಲೇ ಮಾಡಿ. Maybe in the notice board also you can display it. IA 2 of 24 is filed to set aside the abatement of the writ petition. Since the cause of action has surveyed against the legal heirs of the deceased respondent number 5, the abatement of the writ petition as against respondent number 5 deserves to be set aside. Accordingly, IA 2 of 24 is allowed. In view of the orders passed on IA 1 of 24 and 2 of 24, 3 of 24 is allowed, and the LRs of R5 are ordered to be brought on record. Counsel for the petition is directed to amend the cause title and also file an amended cause title. Yes, next.
Malords, the date may be fixed for preliminary
First you
hearing,
amendment
Malords.
ಮಾಡಿ.
Malords,
First you
interim
amend
prayer
it.
has to be considered. That
First
is
you
the reason.
amend it, mister.
I'll do it, Malords. The date may be fixed, my lord.
ನೀವು amendment ಮಾಡಿ move ಮಾಡಿ. Yes, next.
14, Sumana Naganan.
ತಗೊಳ್ಳಿ ಫೈಲ್ ಕೊಡಿ ಅವ್ರಿಗೆ. Please amend it. You will forget.
Lord, this is Lord, matter relating to society. Lord, land was bulk allotment was given to me. There are at least 4 times it has gone up and down the judicial ladder. Every time it is upheld in my favor. Now, my lord, BDA purports to cancel it on a ground which is never raised earlier. That is what is challenged. The matter comes up, my lord. Your lordships may see there are 2 interim orders granted by your lordships, my lord. The first interim order on 8/11/24 was to stay the show cause notice. My lord. Kindly peruse the order of 8/11.
8/11/24 is
Yes, 8/11/24 was the first interim order, my lord. Third para, my lord. Having taken note of the factual aspects on record, it is argued by learned senior counsel for petitioner that acquisition proceeding has reached finality with the Honorable Supreme Court. Prima facie, I felt that action on the part of respondent BDA cannot be accepted. In that view of the matter, there shall be a stay of show cause notice dated 26/9/24 passed by respondent BDA till next date of hearing. Respondent authorities are directed not to take any further steps in the matter without permission of this court.
Yes.
Then, my lord, they purport to do auction. They issue an auction notice to sell this plot. I again come before your lordships, my lord. Kindly now peruse the order of 21/8/25, my lord.
Yes.
Towards the end of that order, my lord, penultimate para, my lord. It is an admitted fact that no permission is sought by any mode, either by filing memo or application. Therefore, BDA has taken a chance of issuing a notification in the teeth of the interim order, which would undoubtedly infringe on the borders of contempt. The justification of BDA is that they are not going to auction the property that is to be granted to petitioner. It is a frail reed that BDA wants to hang on to justify its action
which on the face of it is illegal, it is in the teeth of the interim order so granted. The interim order was to be qualified, it would have been a circumstance altogether different. Interim order is composite, it is concerning the land that is to be allotted to petitioner. In that light, it is ununderstandable as to how the BDA could, without permission of the court, issue auction notification. Then my lord, auction notification is stayed. Now, my lord, what they do is they come physically, my lord, have produced photographs with bulldozers. And they want to now change the entire nature of the property. Kindly peruse the photos, my lord, at page 5-6. I given representation in IA number 1 of 26.
Let him complete.
IA number 1 of 26, my lord, is my IA, which is for your lordship kind consideration today.
Yes.
At page 5, my lord, this is the photograph. It has got, my lord, also the geotagging there and the date. The bulldozers are there. 4 or 5 photographs, my lord, all show those different angles. Then we give a representation to them at page 12.
So they're clearing the site of something, they're not bulldozing anything.
No, they can't do anything, my lord. When the honorable court said no action to be taken, not they are completely in contumacious conduct in violation of the interim order.
Yes.
The issuance of the auction notification itself was illegal. And when they are caught.
What is this? Is this a CS site or what?
See, no, my lord, it's a bulk allotment. This is a society, my lord, very old society. It's a bulk allotment. And my lord, kindly see this, the number of times this case has troubled the courts, my lord. The final notification was in the year 1985 and allotment to me, my lord, is 1998.
Yes.
Look, all that I would want to submit now is, look, on the instructions of the executive engineer, look, we are not doing anything. Your lordship may record that we are not doing anything. So that is the application filed by them. In fact, BBMP also wanted to set up something. We have informed them that this land belongs to us. There is an interim order. So nothing is happening on the land as of now with regard to that IA. Lord, the main matter, my lord, in fact, earlier benches, my lord, where it had come up, my lord, the matter was being heard on the main matter itself. Lord, whether that allotment could have been made. There, my lord, the endorsement why we said that was earlier they were only a society. Subsequently, they amended and make it as a housing cooperative society. That was the reason. Of course, it has a checkered history, as the learned senior counsel has mentioned. But as of now, my lord, we are not doing anything with regard to this matter. Could be heard finally, my lord, on any date.
Please give it in writing that you're not doing anything there. Put it in writing.
He put that. We're not doing anything. But as
The learned senior counsel appearing for the respondent BDA submits that the respondent submit on instructions. The learned senior counsel appearing for the respondents / BDA on instructions submit.
One is BDA.
For respond number 1 - BDA, on instructions submits that the respondent number 1 is not undertaking any development activity in the property in question, and that the apprehension of the petitioner that the BDA is undertaking activity in the property in question is without any basis. Full stop. He also submits that the BDA would not take up any activity in the property until the writ petition is disposed of. The learned senior counsel is directed to without leave of the court.
Yes.
No, till they dispose of the writ petition.
In case, my lord, if the obviously before your lordship said you get disposed of early, my lord.
Until the dispose of this writ petition, the learned senior counsel is directed to instruct the respondent number 1 to file an affidavit of a concerned person to the above effect. Yavat martiri? Tomorrow?
Commissioner.
Monday.
Commissioner.
Commissioner.
Concerned engineer
ಎಲ್ಲಿರ್ತಾನ ಯಾರು ಕಮಿಷನರ್ ಅಂತ ಮಾಡಿಸಿ.
Concerned engineer will file. Will not do it, my lord. And then your lordship may fix a date and it could be disposed.
No, engineer affidavit nobody regards. If it is filed by the commissioner.
This one, my lord, because once we have been castigated by the learned single judge where we tried to auction. Now here we have not done anything. There is no demolition. But my lord, we are making a statement and my lord, affidavit will be filed. After that, we will.
Lord, on 13(3), I give a representation to commissioner Till today, my lord, we are now on the 4th of June. There's no reply, nothing. Let the commissioner, my lord, give this assurance.
Your representation was.
The commissioner to say, "Itara ಮಾಡ್ತಾ ಇದ್ದಾರೆ, ನಿಲ್ಸ್ಬೇಕು, court order ಇದೆ ಅಂತ." I produced it.
Yeah, ಅದಕ್ಕೆ ಕೊಡಬೇಕಲ್ಲ reply ನೀವು.
Reply ಇಲ್ಲ, action ಇಲ್ಲ. Now I'm told they're collecting material.
Then I think the commissioners.
What happened a lot earlier, the matter was being discussed. In fact, the learned single judge said that we dispose of the matter.
No, that is okay.
The matter did not.
That is okay when somebody comes to your office and gives a representation. Is it not? Mate? The commissioner is also sleeping. So file an affidavit to the commissioner. Affidavit of the commissioner of BDA to the above effect. List on Thursday. List on Thursday. Yes.
The all interim orders to be extended, my lord. Because
The orders are extended.
Wait.
Serial number 15.
PC Sitaram Rao.
Without payment, more than 50 lakhs.
Yeah, without payment. Yeah, electricity is supplied to the street lights of classic county layout.
And also the water supply. Kindly peruse the order sheet.
Malaj, may kindly see order dated 9/2/2026, Malaj.
Yes.
There's a direction to the BDA, Malaj, to file objections specifically adverting to our allegation with regard to 3,000 rupees maintenance that they are charging along with the property tax. There is already a direction, they have not filed their objections. Hence, this IA is not considered.
Yeah, 3,000 ರೂಪಾಯಿ ಮೇಂಟೆನೆನ್ಸ್ ಫೀ ಕಲೆಕ್ಟ್ ಮಾಡ್ತಾರೆ.
ಪ್ರತಿ ತಿಂಗಳು ಪ್ರತಿ ವರ್ಷನೂ ಚಾರ್ಜ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಪ್ರತಿ ಸೈಟ್ ಓನರ್ ಹತ್ರ. More than 300 sites are there.
It's Kamala, if the roads and other civic communities have been relinquished. No, if the roads have been relinquished to BDA.
Consumer is a developer.
If the roads have been relinquished to the BDA, it is a BDA's responsibility to maintain the streets.
My lord, roads, he has to submit, my lord.
Correct.
I am the supplier of electricity, my lord. Kindly.
Right. You are a supplier of electricity.
Please, my lord.
Only to the street lights.
Including water supply for the.
The water supply ನೀವೇನು ಅಪೇರ್ ಆಗ್ತಿಲ್ವಲ್ಲ.
ಇಲ್ಲ, electricity is used for street light and water supply.
What water supply?
For the residents, my lord.
Electricity disconnect
to pump.
Yes, my lord.
To pump water.
Yes, developer used to pay earlier, my lord. They are in huge arrears. They are filed.
So BDA relinquish ಆಗಿದ್ರೆ who has to pay the cost?
Relinquishment deed ಅಲ್ಲಿ developer has relinquished the land to the BDA, subject to condition that he would maintain the private layout till it is handed over to local body. Local body ಇನ್ನೂ ಹ್ಯಾಂಡ್ ಓವರ್ ಆಗ್ಲಿಲ್ಲ.
ರಿಲಿಂಕ್ವಿಶ್ ಮಾಡಿದ್ರೆ ನೀವ್ ಹೆಂಗ್ ಕಂಡೀಷನ್
ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡೋದು ಅವ್ರ ಜವಾಬ್ದಾರಿ.
ರಿಲಿಂಕ್ವಿಶ್ ಮಾಡುವಾಗ ಡೆವಲಪರ್ ಮೇಲೆ where is the responsibility for him to maintain?
So that's what the
relinquishment deed comes into force the moment it is executed.
Correct.
So now till hand over ಮಾಡೋವಾಗ ನೀನು how can you impose such a condition?
ಪಾರ್ಕ್ ಇವರೆಲ್ಲ ಡೆವಲಪ್ ಮಾಡೋದು ಕಾರ್ಪೊರೇಷನ್.
ನೀವೇ ಮಾಡಬೇಕು. ಹ್ಯಾಂಡ್ ಮಾಡಬೇಕು ಇಲ್ಲ ಕಾರ್ಪೊರೇಷನ್ ಕೊಡಬೇಕು.
ಸರ್ ಈಗ ಏನಾಗಿದೆ GBA ಬಂದಿದೆ. It is integrated to GBA.
BDA is collecting maintenance charges of 300 rupees or 3,000 rupees from every site owner.
My lords, they are not. They are not collecting. What he is saying that he is paying tax to the BDA.
Tax ಬಿಟ್ಟು maintenance charge ಅಂತ.
3,000 ರೂಪಾಯಿ ಚಾರ್ಜ್ ಮಾಡ್ತಿದ್ರು. ಇಯರ್ಲಿ ಮೇಂಟೆನೆನ್ಸ್ ಫೀ ಅಂತ ಹೇಳ್ತಿದ್ರು. ನೋಡಿ, there is an order passed by this court. Adverse to the contention of the petitioner that yearly payment of property tax, including rupees 3,000 towards maintenance fee, which according to the petitioner would take care of the common amenities.
Malaj, may kindly take to page 42, Malaj. That will answer his question. Page 42. Property tax 4,963 ಬೇರೆ. Maintenance fees and the separate charge ಮಾಡ್ತಾ ಇದ್ದಾರೆ 3,000 ರೂಪಾಯಿ. This is from every property owner.
ಹಿಂಗೆ ಮೇಂಟೆನೆನ್ಸ್ ಫೀ ಏನಿದು?
ಅದು ರೋಡ್ಗೆ ಅಂತ ಹೇಳಿ ನಾವು ಮೇಂಟೆನೆನ್ಸ್ ತಗೊಂಡು
ರೋಡ್ ಮೇಂಟೈನ್ ಮಾಡ್ತಾ ಇಲ್ಲ, ಏನು ಮೇಂಟೈನ್ ಮಾಡ್ತಾ ಇಲ್ಲ.
ಸ್ಟ್ರೀಟ್ಸ್ ಗೆಲ್ಲ ನಮಗೆ ಸಂಬಂಧ ಇಲ್ಲ.
ಒಂದ್ಸತಿ ರೋಡ್ ನಿಮ್ದಂತ ಆದ್ಮೇಲೆ ಮೇಂಟೆನೆನ್ಸ್ ಫೀ ಯಾರು ನೀವ್ ಮಾಡ್ಬೇಕು ತಾನೆ ರೋಡ್ ಒಂದ್ಸತಿ
Correct.
ರೋಡ್ ನಿಮ್ದು ಅಂತ ಆದ್ಮೇಲೆ ಮೇಂಟೈನ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ನೀವ್ ತಾನೆ.
Now, what I can make a submission is that, my lords, now BDA, my lords, the planning authority has merged with GBA. But we have sent entire files to the GBA. Let him make a GBA as a party. Now, the prayer sought is against one of the prayer sought is against the BDA. But in the light of the commencement of GBA Act.
Correct, but till the date, till the date you handed over the area to GBA or the corporation, you are bound to pay the electricity charges because you are collecting maintenance fee.
But relinquishment deed speaks something. Kindly see page number
ನೀವು
20.
ಯಾಕೆ ಚಾರ್ಜ್ ಮಾಡಿದ್ರಿ ಮತ್ತೆ?
Correct.
ಅವನ ಹತ್ರ ಅವ್ನಿಗೆ ಹೇಳಿದ್ರಿ ಇವ್ರ ಹತ್ರನೂ ಕಲೆಕ್ಟ್ ಮಾಡ್ತಿದ್ರಿ ಡಬಲ್ ಧಮಾಕ.
ಅಷ್ಟೇ ಪೇಜ್ 20.
No, you point out under what provision of law you are demanding this maintenance fee, demanding and collecting.
28A.
ಓದಿ
ಅದು ಸೆಕ್ಷನ್ 28A.
ಓದಿ. BDA ಕೊಡಿ.
Duty to maintain streets, etc. It shall be incumbent on the authority to make a reasonable and adequate provision by any means or measures which it is lawfully competent to use or take for the following matters, namely the maintenance, keeping in repair, lighting and cleansing of the streets formed by the authority till such streets are vested in the corporation. B, the drainage, sanitary arrangement and water supply in respect of the streets formed by the authority. Next, 28B. Levy on the tax on lands and buildings. Notwithstanding anything contained in this act, authority may levy tax on lands or building or on both situated within its jurisdiction, hereinafter referred to as property tax, at the same rates at which such tax is levied by the corporation within its jurisdiction. The provisions of Karnataka Municipal Corporation Act 1976 shall mutandis applies to the assessment and collection of property tax.
ಎಲ್ಲಿದೆ ಇದು ಮೇಂಟೆನೆನ್ಸ್ ಫೀ ಎಲ್ಲಿದೆ?
That's what it's not there. ಅಷ್ಟೇ ಇರುತ್ತೆ ಕೇಸ್.
Now I have to go and check my property tax receipt.
Sir, GBA na party ಮಾಡಿ.
That's right, but so far as the income tax, the electricity dues are concerned, it is you who has to pay.
We have not
collected it from the site owners.
We have issued an endorsement quoting the relinquishment deed saying that we can't do it.
No.
My lord, I am the supplier, my lord. Consumer is not a consumer at all, my lord. Writ petition itself is not maintainable.
Who is not
my
a
submission.
consumer?
Writ petition is by an association, my lord. He is not a consumer, my lord.
Correct.
So now my dues, electricity dues may kindly be ordered to
Please
be.
proceed against the BDA.
My lord, why should I, my lord? I am the supplier, my lord. Electricity
Why should
consumption
I-
charges has to be paid. Please, my lord.
On whose request?
Earlier, it was used to pay by the developer, my lord.
ಆಯ್ತು, ಡೆವಲಪರ್ ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡಿದ್ದಾರೆ.
At that time, we don't know, my lord.
You do not know ಅಂದ್ರೆ now they
My lord, I can't go against him, my lord. Consumer,
ಡೆವಲಪರ್
Please.
ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡಾಯ್ತು, ರಿಲಿಂಕ್ವಿಶ್ ಮಾಡಾಯ್ತು BDA-ಗೆ.
somebody has to pay the electricity.
So it is the
More than
BDA which
50
has to
lakh,
pay.
50 lakhs are due, my lord. Please, my lord.
IA
I may kindly be considered.
Yes, I will consider.
My lord.
IA 1/25 is filed by the respondent number 2 and 3 to vacate the order of stay granted by this court. It is stated in the affidavit accompanying the application that the petitioner is a welfare association of residents. It is contended that electricity supply is provided to nearly 300 houses which have come up in the private layout. It is contended that though electricity supply is a civic amenity, it cannot come free. And that the residents of the layout are consumers who are bound to pay the charges. It is contended that the streets have to be lighted by the it is contended that though the respondent number 2 and 3 are under an obligation to light up the streets, it is the residents who have to bear the electricity charges. It is also contended that electricity is used to pump water from the borewell and supply to the residents. And for this purpose too, it is the residents who have to pay the electricity charges. It is contended that as of 2nd July 2025, it's contended that on 2nd July 2025, a letter was addressed to the developer demanding a sum of rupees 41,27,775. It is contended that the said amount is not paid till date, and the respondents 2 and 3 are not charitable institutions to supply electricity power free of cost. Therefore, it is prayed that the interim order granted by this court on 9/2/2026 be vacated as a sum of
5/8, my lord, the interim order, 5/8/25, my lord.
5/8/25.
Yes, my lord.
As a sum of rupees 42 lakhs is overdue. Per contra, the learned counsel for the petitioner submitted that the developer, after developing the layout in question, had relinquished all these roads, civic amenities to the Bangalore Development Authority, and therefore it is the authority which is bound to maintain the roads and also pay the charges for consumption of electricity. Consumption of electricity for lighting up the streets, full stop. He also submits that the BDA has been collecting a sum of rupees 3,000 per month from every site owner per year from every site owner towards maintenance charges, and that these maintenance charges are towards payment of the electricity charges and also for towards other amenities. He submits that the BDA has till date not filed its statement of objections, setting out the reasons for collecting a sum of rupees 3,000 per year towards maintenance. We therefore praise that the application filed by the respondents 2 and 3 cannot be considered unless there is clarity as to whether the BDA is bound to pay the electricity charges. I consider submissions of the learned counsel for the respondent number 2 and 3 and the learned counsel for the petitioner. Full stop. This court, in terms of an order dated 9/2/2026, had noticed that the BDA, while collecting the property taxes from the owners of the sites formed in the layout, was also collecting a sum of rupees 3,000 per year towards maintenance fee. Full stop. The learned counsel for the BDA authority was not able to convince this court as to under what provision of law the BDA was collecting a sum of rupees 3,000 per year as maintenance fee. Full stop. It is here the learned counsel for the Bangalore Development Authority did not dispute the fact that after the layout was developed in all respects, the civic amenity sites, comma, roads and other amenities were relinquished in favor of the Bangalore Development Authority. And therefore, comma, it is the duty of the authority to maintain the streets and other civic amenities. Full stop. Thus,
Can I
comma,
interfere?
the,
Not dispute ಅಂತ ಬೇಡ, relinquishment deed ಅಲ್ಲಿ ಡೆವಲಪರ್ ಏನ್ ಹೇಳಿದ್ದಾರೆ ಅಂದ್ರೆ ಫರ್ದರ್ ಅಗ್ರೀಡ್ ಬೈ ದಿ ಫಸ್ಟ್ ಪಾರ್ಟಿ ಟು ಮೇಂಟೈನ್ ದಿ ಪ್ರೈವೇಟ್ ಲೇಔಟ್ ಟಿಲ್ ಇಟ್ ಈಸ್ ಹ್ಯಾಂಡೆಡ್ ಓವರ್ ಟು ದಿ ಲೋಕಲ್ ಬಾಡಿ ಅಂತ ಬರ್ತದೆ.
then why are you collecting?
ತಪ್ಪಿದೆ.
ಕಲೆಕ್ಟ್ ಏನಕ್ಕೆ ಮಾಡ್ತಿದ್ರಿ? ಏನಾಯ್ತು? Therefore, at this stage, comma, this court is of the opinion that it is a duty of the BDA to maintain the streets and also pay the electricity charges incurred in maintaining the street lights. Full stop. Under the circumstances, comma, the interim order granted by this court restraining the respondent number 2 and 3 from disconnecting electricity to the street lights do not warrant to be vacated. Consequently, IA 125 is rejected. The learned counsel for the respondent number 1 is directed to comply with the order dated 9/2/2026 passed by this court. Yes.
My lords, may I request
It is open for the respondent number 2 and 3 to escalate their demand by raising a claim with the respondent number 1.
May I request to make a reference with regard to the relinquishment deed?
ಯಾವುದು?
Relinquishment deed executed by
ಆಯ್ತು, ಒಂದು ಸೆಂಟೆನ್ಸ್ ಹಾಕಿದ್ರೆ learned counsel for the respondent number 1 submits that as per the relinquishment deed, comma, it was the duty of the developer to maintain the layout in all respects until it was handed over to the municipal
Local
corporation.
bodies.
Yes.
Great.
Still number 16, VB Shivkumar.
Yeah, please. Second respondent. Before a week's accommodation, I will file my statement of objections.
Learned counsel for the respondent number 2 seeks time. This on so and so.
Some urgency.
ಯಾವತ್ತು ಬೇಕು ಹೇಳಿ?
25th.
For objection ಹಾಕ್ಬೇಕಲ್ಲ, 2026 matter.
25th, my lords.
Let them file objections.
As quick as it could be.
25th, my lords. 25th.
Yes, next.
Please,
So and so.
Still number 17, Anusha Nandish.
Usha Nandish.
Apologize, serial number 10, there's an interim order in force, it's been.
Please wait, Mr.
I apologize.
Anusha Nandish,
Lords, appearing for the petitioner, my lords.
same matter.
Matters pertaining to betterment tax, my lords. Notice was issued in the earlier roster. Batch of matters were disposed of, my lords.
Lord, in those matters, my lord, the issue was, my lord, they had given a
You
representation.
represent?
BDM.
Ah,
Lord, in those matters, what had happened, they had given a representation on the demand notice issued by us. Pursuant to which, my lord, the court was pleased to say that the demand notice issued by us should be treated as 21-1 notice and not a demand notice wherein we can collect the interest.
Yes.
Now here, my lord, we have issued a demand notice, there is no representation yet from their end. So at least insofar as this petition is concerned. If my lord is my learned friend
let
is
them give their objections.
Yes, Lords, there was a direction. I have given the objections. I have also filed it along with the memo. There was a direction to me by this honorable court, my lords, to file my objections.
Then you consider that. ಎಲ್ಲಿದೆ ಅದು? Where is the order?
I filed the last date of hearing, my lords.
Huh?
The last date of your hearing, there was a direction to
To file objections.
file objections to
in
the
that case,
BDA.
we'll pass appropriate order.
That even they will pass appropriate orders.
Please, my lords, so far as other petitions are concerned,
No, but
similarly,
if there is now a demand, that demand has to go.
No, this can be termed as a demand under 21-1.
Yes.
21-1 may kindly be seen for a moment. This is a notice which will be issued to each of the land owner towards the betterment tax.
Where is the impugned order?
my lords,
Annexure B, page 38.
38.
resolution as well as demand notice is challenged, my lords. There are two demand notices in this petition, my lord.
Except B1 is a BDK notice, demand notice.
Demand notice, yes.
Ah.
To which, my lord, they can give a representation, which my learned friend is saying, my lord, they've given now. In that background, my lord, we'll consider the representation and pass appropriate orders under 21-2. 21-1 was the notice which was issued to the petitioner.
My lords, in fact, my lords, one submission that I would like to place, my lords, 21-1 cannot be a demand notice at all, my lords. It has to be a show cause notice. My lords, they give me 90 days time period and they start calculating interest, my lords.
is why, my lord, I'm making this submission. It can be considered as a show cause notice. It may be termed as a demand notice, but the contents of which, my lord, and thereafter the reply which they have given can be termed as a show cause notice and will pass appropriate orders.
Insofar as this petition is concerned, my lords, there is one single unit. It is one site. Error demand notice kotidare for first floor different, second floor different. It is one single unit. There were 2 regularization certificates that were issued, my lords.
If there are 2 kitchens, then is there any, does it make any
But so
difference?
far as betterment tax is concerned, it's payable on the land, my lords.
Yes.
So what happens in Shivaram Karan, what had happened, my lord, because, my lord, they made 2 applications to the committee seeking regularization of one property as per them. They ought to have made 1 application. So
2 applications.
They made 2 applications.
That's
They filed 2 applications before the committee seeking regularization of one building having 2 floors. This is a submission made by the petitioner. In that background, 2 regularization certificates came to be issued. Insofar as 2 regularization certificates, we have to issue 2 betterment tax notices. There can't be 1 because of the application made by them.
The primary submission, my lords, betterment tax has to be assessed per land basis, my lords.
Yes.
There is a general order passed by the BDA, my lords. For one village, it is this much. For one village, it is this much. My lords, the petitioner is from Ramagundanahalli village, my lords. The rate at which it is charged is 1028 per square foot, my lords. And the border village, my lords, which is Kempanalli, Veersagra and all, the lowest is rupees 43, my lords.
That you can challenge it after the demand is raised.
Precisely what I am submitting, my lords. The assessment is what we are disputing, my lords. And if we are disputing the assessment, my lords, according to 21(4), there has to be a reference to the district court.
Yes.
Instead, my lords, first para of the demand notice after the tabulation, my lords.
Let them consider your objections.
Please, my lords.
Barkult. Can we dispose it off?
Please.
My lords, in one submission, my lords, in the event it is not
No,
considered.
it can be treated as one demand. Because if you look at the regularization certificates,
please,
it is in respect of one property, though it is for 2 different floors.
2 different floors.
ನೆಲ ವಿಸ್ತೀರ್ಣ 425.6 ಇಂಟು ಚದರ ಅಡಿ ಒಟ್ಟು ಕಟ್ಟಡ ವಿಸ್ತೀರ್ಣ 1029.
I suggest this, my lord, because I don't have a copy of the representation, my lord.
1768 is the Niveshana.
Just give it to you.
Madam, you please come to both the certificates. It says Ramagundanhalli Gramada survey number 57/2
Please.
2880 ಚದರಡಿ ಅಳತೆಯ ನಿವೇಶನ ಸಂಖ್ಯೆ ಅಲ್ಲಿ ನಿರ್ಮಿಸಿರುವ so and so. ಇನ್ನೊಂದರಲ್ಲಿ 1768 ಚದರಡಿ ಅಳತೆಯ ನಿವೇಶನ. So there are 2 sites.
Built up area of 2 different sites, my
No.
lords. Single site, my lords.
It says, please read. Can you read Kannada?
Please, my lords.
ಓದಿ.
ಪ್ರಾಧಿಕಾರ ನಿರ್ಮಿಸಿರುವ ಡಾಕ್ಟರ್ ಕೆ ಶಿವರಾಮ್ ಕಾರಂತ್ ಬಡಾವಣೆಯ ರಾಮಗೊಂಡನಹಳ್ಳಿಯ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 57/2 ರಲ್ಲಿನ 2880 ಚದರ ಅಡಿ ಅಳತೆಯ ನಿವೇಶನ ಸಂಖ್ಯೆಯಲ್ಲಿ ನಿರ್ಮಿಸಿರುವ ನೆಲ ವಿಸ್ತೀರ್ಣ 1589.75 ಚದರ ಅಡಿ, ಒಟ್ಟು ಕಟ್ಟಡದ ವಿಸ್ತೀರ್ಣ 2438.8 ಚದರ ಅಡಿ ಅಳತೆಯು 2 ಅಂತಸ್ತಿನ ಈ ಕೆಳಗಂಡ ಚಕ್ಕುಬಂದಿಗೆ ಒಳಗೊಂಡಿರುವ ಕಟ್ಟಡವನ್ನು ನಾರಾಯಣ ಸನ್ ಆಫ್ ಸೋ ಅಂಡ್ ಸೋ ರವರ ಪರವಾಗಿ ಸಕ್ರಮಗೊಳಿಸಲಾಗಿದೆ. ನಿಬಂಧನೆ 60/40 ಯೋಜನೆ ಪ್ರಕಾರ ನಿವೇಶನ ವಿಸ್ತೀರ್ಣವನ್ನು ನಿರ್ಧರಿಸಲಾಗುತ್ತದೆ. ಕಟ್ಟಡ ಮಾಲೀಕರು
next ನೋಡಿ. It says here, there is a reference of 2 floors. Next, there is a reference of 1 floor. And kindly see the building plinth area. Building plinth area is also different.
But what is this 1768 ಚದರಡಿ ಅಳತೆಯ ನಿವೇಶನ?
Please, my lords.
Read the second line. In the first regularization certificate, it is 2880 square feet alateya niveshana. In the second one, it says 1768 chadaradi alateya niveshana.
2 different.
It appears there are 2 different sites.
My lords, it is not, my lords, is my submission. However, my lords, the minute my objections are raised, they are open to come for inspection, my lords. All that we are saying is, my lords, if it is still
Petitioners have challenged. Petitioner has challenged the demand notice dated 12/10/2025 issued by the respondent number 2 demanding betterment charges. Full stop. The petition is filed on various grounds, and it is various grounds, one of which is that the impugn notices are issued without issuing appropriate show cause notices as required under section 24,
21, my lords.
21-1.
under section 21(1) of the BD Act 1976. So during the pendency of this writ petition, this court had permitted the petitioner to file a statement of objections by treating the demand notice. Ilva. When did this court permit you, madam?
So let's, the last date of hearing, my lords.
Last date of hearing is 24/4/2026.
Please, my lords.
There's nothing in this.
There was an order passed, my lords, and I filed a memo with the objections that was filed. This is the memo that I had filed.
Correct, but where is the order? There's nothing mentioned in the order. Source kodi aur. It appears that the petitioner has filed objections to during the pendency of this writ petition, the petitioner has filed objections to the demand notice. Full stop. In that view of the matter, this writ petition deserves to be disposed of, directing the respondent number 2 to consider the demand notice, impugned demand notices as a show cause notice under section 21(1) of the BD Act, and to consider the objections filed by the petitioner and thereafter pass appropriate orders. In view of the above, this writ petition is allowed in part. The impugned demand notices issued by the respondent number 2 shall be treated as show cause notices under section 21(1), and the respondent number 2 shall consider the objections filed by the petitioners on
27/4/2026.
On 27/4/2026 and pass appropriate orders. All contentions of the petitioners are kept open to be urged before the respondent number 2.
In the earlier batch of matters, there was specific observation that if the aspect of assessment is not resolved, let the course be taken as per 21(4), because that is a reference to.
It is needless to mention that if the issue is not resolved,
The assessment has not been agreed.
if the assessment is not
agreed by the.
is not agreed by the petitioner, the petitioner is entitled to avail the remedy as provided in section 21(4) of the BD Act.
Obliged.
I need not say that, madam. It is already there. Oh.
Serial number 18.
Karthik Surya Prakash.
Lord, the petitioner's land has been acquired. The petitioner has challenged the preliminary notification as being resigned at first, and secondly also for quashing of the section 21 notice under the Land Acquisition Act, my lords, on the ground that no right of personal hearing was afforded. Insofar as the prayer for resignment of the preliminary notification under the Land Acquisition Act, my lords, the section 19 subsection 7 is being invoked. Section 19 subsection 7.
No, acquisition is under what act?
Land Acquisition Act 2013, my lords.
Ah.
The 31/2019 is the date of the preliminary notification, my lords.
Yes.
Annex A, page 18, my lords.
Ah.
Now, under section 19, the said notification had to be concluded within a period of 1 year. Otherwise, it stands resigned unless there's an extension order which is duly notified and also uploaded on the website concerned.
Yes, madam.
This is second round of litigation.
No, but-
The petition came to be dismissed to approach the alternate remedy. And there is a LAC also which has been filed, my lordship. It is pending, I think, annexure.
No, but before issuing a notification of section 19, have you extended the time?
May I submit, my lord?
The same.
These issues has been already considered by the Honorable Court in another writ petition. And the preliminary notification and final notification has been upheld.
The final notification, where is the final notification?
Final notification dated 18/1/23.
27/1/2023, my lords. Annexure.
Annexure?
Annexure C, my lords.
You're not challenging the final notification?
My lord, the notification itself stands resigned if it is not published within a period of 1 year.
Yes.
is the requirement. Therefore, we hold that the entire acquisition agreement stand rescinded. The second prayer is that the section 21 notice is in violation of the right of personal hearing.
Just find out, Mr. whether the
Madam, very same advocate has filed another writ petition. In that writ petition,
hold your horses for some time.
in that writ petition, there is already an order by this honorable court upholding both the notifications.
Both the notifications, even the final notification?
Yes,
Illegal.
is upheld. I have
Where
filed
is
the
that?
copy of the, last time ಕೊಟ್ಟಿದ್ದೀನಿ.
List of citations.
Writ petition number 19828/2024. ಸೇಮ್ ನೋಟಿಫಿಕೇಶನ್ ಇವರು ಇಲ್ಲೇನ್ ಚಾಲೆಂಜ್ ಮಾಡ್ತಿದ್ದಾರೆ ಅದೇ ನೋಟಿಫಿಕೇಶನ್ ಅಲ್ಲೂ ಆರ್ಡರ್ ಆಗಿದೆ.
ಯಾರು ದೇವರಾಜು ಅಂದ್ರೆ ಯಾರು?
DG Devaraju is a petitioner.
Whether this Devaraju is a party in the earlier petition?
No, my lords.
ಅದರಲ್ಲಿ ಇಲ್ಲ ಡಿಫರೆಂಟ್.
Okay, where is the final notification?
ಹೌದು, ಎಲ್ಲರೂ ಇದ್ದಾರೆ ಅದರಲ್ಲಿ, ಎಲ್ಲರೂ ಇದ್ದಾರೆ ಫೈನಲ್ ನೋಟಿಫಿಕೇಶನ್.
Page 25.
Please wait, mister.
Challenge is, my lord, page 5 of the order. Same date, same final notification and same preliminary notification.
Now, was this contention considered?
Yes.
ಎಲ್ಲಿದೆ? Within 1 year issue ಮಾಡಿಲ್ಲ ಅನ್ನೋದು.
Detailed order is passed.
Where is it considered, mister? Detailed order is passed. Where is it considered? Within 1 year, you are supposed to issue a final notification unless the time is extended.
Yes, ma'am.
Where is it considered in the earlier petition?
Time is extended. Page 25 may kindly see.
Must ಹೇಳಿ.
In the same order, page 25. ಅಧಿಸೂಚನೆ ಎಕ್ಸ್ಟೆಂಡೆಡ್ ಅಧಿಸೂಚನೆನೂ ಹಾಕಿದ್ದಾರೆ ಅದರಲ್ಲಿ.
ದಿನಾಂಕ 27 ಇದು ಯಾವತ್ತಿದು? 27/8/2022 ರಿಂದ 26/2/2023 ಕಾಲಾವಧಿಯನ್ನು ವಿಸ್ತರಿಸಿ ಆದೇಶಿಸಲಾಗಿದೆ.
ಹೌದು, within one.
ಇದು ನೋಟಿಫಿಕೇಶನ್, ಪ್ರಿಲಿಮಿನರಿ ನೋಟಿಫಿಕೇಶನ್ ಡೇಟ್ ಏನು?
31/2019 ಮೇಡಮ್.
30
1/19/19 2019.
ಮತ್ತೆ 1 ವರ್ಷ ಯಾವಾಗ ಎಕ್ಸ್ಪೈರ್ ಆಗುತ್ತೆ? ಒಂದು ವರ್ಷ ಯಾವಾಗ ಎಕ್ಸ್ಪೈರ್ ಆಗುತ್ತೆ?
2020.
20 ಇಂದ ಎಕ್ಸ್ಟೆಂಡ್ ಯಾವಾಗ ಮಾಡಿದಿರಿ?
Page 25, my lord. Page 25 of the writ petition.
25.
ಹ್ಮ್ 2020 ಇಂದ ಎಲ್ಲಿ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿದೆ?
Page 25 of writ petition. 4th line, 5th line, my lord. 31/2019 ರಂದು ಸರ್ಕಾರದ ಅಧಿಸೂಚನೆ ಹೊರಡಿಸಿದ್ದು ಈ ಅಧಿಸೂಚನೆ ರಾಜ್ಯ ಪತ್ರದಲ್ಲಿ ದಿನಾಂಕ 22/2/2019 ರಂದು ಪ್ರಕಟಗೊಂಡಿರುವ ಮೇರೆಗೆ 2013 ಮೂಲ ಕ್ರಯ ಕಾಲಂ 11 ರಡಿ ಕ್ರಮಾಂಕ 2985 ರಿಂದ 299 ದಿನಾಂಕ 28/2/2019 ರಲ್ಲಿ ಅಧಿಸೂಚಿಸಿ ಪ್ರಕಟಿಸಲದಂತೆ ಕಲಾಮ.
What happened is, it is during COVID time. That is why that has been considered by the Honorable Court and the notifications are upheld.
ಸರ್, ಅವಾಗ್ಲಿಂದ ಕೇಳ್ತಿದ್ದೀನಿ, ಕನ್ಸಿಡರ್ ಬೈ ದಿಸ್ ಆನರಬಲ್ ಕೋರ್ಟ್ ಎಲ್ಲಿ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ದಾರೆ? ಯಾವ ಪೇಜ್ ಅಲ್ಲಿ?
Page 46, inner page 46. Referring the order of Ganganna case, in the last para, the petitioners in the case at hand have submitted their objections to the final notification. Therefore, section 21 permits the petitioner to be heard, more so in the light of the facts of gross variation with the extent of acquisition insofar as the award and actual acquisition. Written objections, though filed by the petitioners and appears to have been considered, it would not be in the compliance with the mandate of statute, which requires personal hearing to be granted. In the case before the High Court of Bombay, written objections were, though filed, it was held that written objections being filed by the advocate would not mean that there is a compliance with the mandate of the personal hearing. There is no document produced to show that enquiry has been conducted under Section 23. After following the procedure under Section 21 of the Act in the case on hand, in that light, the petitioner deserves succeed, albeit in part. The challenge to the acquisition fails, but the challenge to the violation of 21 of the Act succeeds.
Correct, but 31 2020 ಒಳಗೆ
Yes, ma'am.
has any extension been notified? 1 year time alva?
Although that is not but done because of the COVID times, madam. That is been considered by the court in K. Ganganna case, page 13 ನಲ್ಲಿ ಅದನ್ನು ರೆಫರ್ ಮಾಡಿದ್ದಾರೆ. That case has been referred. Para 9.4, page 30. Para 9.5 ನಲ್ಲಿ explanation ಇದೆ. Limitation ಬಗ್ಗೆ.
What is the purpose for which this acquisition is made?
For railway project.
Railways.
Yes, Mr.
Milords, there is no discussion explicitly as to how 19 subsection 7, which is a binding statutory provision, can be circumvented in the present case. Secondly, also in Ganganna's case, there was a death of a special land acquisition officer. So there were extraordinary circumstances in that case because there was a death of the land acquisition officer. It was also explicitly stated that because of COVID-19 conditions, there were specific grounds made out. Thirdly, in that case, Railways was not made as a party, and that was one of the factors which prevailed with the court in the case of Ganganna. I produce a citation including the judgment in the case of K. Ganganna. There is a coordinate bench judgment in the case of Chandrappa HC Mallots, which specifically deals with section 19 subsection 7. That has also been provided in the list of citations that was filed on the last date of hearing.
So the COVID-19 month is March 2020 alva?
That is correct, but the same
Yes.
I'll file my objections, my lord.
Who has issued the notification?
Government, one is DC.
The state government or the
State
central
government, my lords.
State.
Barkul. HCGP is directed, notice ಆಗಿದ್ಯಾ?
Notice has been ordered, my lord. They've been served.
It is stated by the Learned Counsel for the Learned Central Government Council for respond number 6, 7 and 8 that the final notification is issued during the extended period as provided under section 19 subsection 7 of the Act 2013. Full stop. It also contains Gangana in Chandra in WP number 3768 of 2023 has considered in
3768
19/8/28 of 2024 and connected petitions where it was held that the acquisition is for the purpose of laying a railway line and railway line and in view of the judgment passed by another coordinate bench of this court in K. Ganganna versus State of Karnataka, the violation pointed out by the Learned Counsel for the petitioner cannot be projected by the petitioners to invalidate an acquisition. Full stop. He therefore submits that when the similar question was considered by a coordinate bench of this court, this petition is also liable to be, this contention urged by the petitioner is liable to be considered on this very same lines. Next para. After hearing the Learned Counsel for the petitioner, it is seen that the preliminary notification was issued on 30/1/2019 and in view of the proviso to section 19
Subsection 7.
Huh?
Subsection 7, my lords.
Within 1 year, within a period of 12 months, in view of the third proviso to section 19(2) of the Act 2013, the final notification had to be issued in 12 months from the date of publication of the preliminary notification, subject to the same being extended as provided under section 19(7). Failing which, the preliminary notification shall be deemed to have been rescinded. Full stop. The extension of the time prescribed under the third proviso to section 19(1) appears to have been made on
Final notification 18/1/23.
Appears to have been made on 2022 ittalla
15/9/2022.
15/9/2022. The contention of the Learned Counsel for the petitioner, this contention of the Learned Counsel for the petitioner, 59/22. However, this extension was not made within 1 year from the date of preliminary notification, but was made beyond the said period. Full stop. Therefore, the question that arises for consideration in this petition is whether the law as declared by a coordinate bench of this court in Gangana prevails, or the judgment of another coordinate bench of this court in Chandrappa prevails. Full stop. Thus, to examine the aforesaid question, the learned counsel for the respondents are directed to file their statement of objections. This for preliminary hearing in B group on so and so. Until then, the respondents are directed to hold their hands and not take any action in respect of the land of the petitioner in respect of the property mentioned in the schedule to the writ petition. Yes. Next.
Serial number 19, Vikram Singh.
For preliminary, let them file objections. We'll consider. Vikram Sinha.
Lordship, for the petitioner,
Ah.
Lordship, this is the matter where the respondent KBD acquired 36 square feet of land out of the scheduled property, Your Lordship, for the purpose of suburban railway.
Yesterday, what is the size of your plot?
3,000 square feet, Your Lordship.
Out of which, how much is acquired?
336 square feet they have, square meters they have acquired, Your Lordship.
ಎಷ್ಟಾಯ್ತಲ್ಲಿಗೆ?
Out of 3,000 square feet, they have acquired 10%, Your Lordship, 360 square feet.
Yes.
Which is in middle of the property, Your Lordship.
Middle
of the property. And there is no access to that 36 square meter, Your Lordship, which they have acquired. And
Recently, 1/6/2020.
Huh?
Recently, 4 days back, I filed a wakalat. I have to get instruction. I pay
But
for
for
1 week time.
Learned counsel for the respondent number 2 and 3
And I am-
seeks time to secure instructions. Full stop. Since it is the case of the petitioner,
Yes,
that
one humble
36
submission.
square meters of property is sought to be acquired in the middle of a property belonging to the petitioner, which has no access or connection to the project area. The respondents are directed to maintain status quo till the next date of hearing. List on yavat beku.
One humble submission, Your Lordship. We are not disputing the acquisition, Your Lordship. My humble submission, the property is in commercial nature, Your Lordship. They have fixed the price as per the residential. I have filed 5 representation to consider as per the commercial and
Challenge
pass
you,
the
seek
award.
for reference.
Your Lordship, I have seeking the mandamus for the considering of the representation itself.
Please come to section 64. Come to section 64. What does it say? ಸಿಕ್ಸ್ಟಿ-ಫೋರ್ ಓದಪ್ಪ. ಯಾವ ಬುಕ್ ತಂದಿದ್ಯಾ?
KBD.
KDB da?
Yes, Your Lordship.
2013 ಆಕ್ಟ್ ತಗೋ ಕೊಡಿ. ಅದು ಹೊಡೆದಾಕಮ್ಮ. Come to read section 64(1).
Any person interested who has not accepted the award may by written application to the collector require that the matter be referred by the collector for the determination of the authority, as the case may be, whether his objections be to the measurement of the land, the amount of the compensation, the person to whom it is payable, the right of rehabilitation and resettlement under chapter 5 and 6 of the appointment of the compensation among the persons interested, Your Lordship.
ಏನಂಗಂದ್ರೆ ಅರ್ಥ?
We have to file an application before the date.
ಅಲ್ಲೋಗ್ಬೇಕು ತಾನೆ, ಮತ್ತೆ ಇಲ್ಲಿಗೆ ಯಾಕೆ ಬಂದ್ರಿ?
Lordship, section 29 class 3, Lordship, KBD, if no agreement is arranged between the landlord and government, Your Lordship, they have to refer the matter to the DC, Your Lordship, to determine the price.
Correct.
They haven't completed
But they
section
have passed a general award.
Yes, Your Lordship.
They passed a general award. If you are aggrieved by the compensation determined, you follow the process provided under section 64. ಅರ್ಥ ಆಯ್ತಾ?
Yes, Your Lordship.
So therefore you pursue the remedy under section 64. We cannot direct them. ಬರ್ಕೊಳ್ಳಿ. Award notice ಬಂದಿದೆ ನಿಮಗೆ.
Yes, Your Lordship.
So therefore, if you are agreeable for this, you go ahead.
Before the award notice, Your Lordship, I have filed 5 representation, Your Lordship. None of they have considered.
ಅದನ್ನೇ ತಕೊಂಡು ಹೋಗ್ಬೇಕು ಅಲ್ಲಿಗೆ. ಬರ್ಕೊಳ್ಳಿ. The petitioner has sought for a writ in the nature of certiorari to quash the award notice bearing number so and so dated so and so issued with the respond number 3 under section 77(2) of the land acquisition of the right to fair compensation, so and so 2013. Huh? The petitioner has also sought for a writ in the nature of mandamus to direct the respondent number 3 to consider the representations dated 20th of January 2026, 29/126, 30/126, 13/2/26, and revise the award by treating the property acquired as a commercial property, and to pass a fresh award in accordance with section 29(3) of the KIDB Act, and also in accordance with section 26 and 30 of the Act 2013. She has also sought for a direction to the respondent number 3 to rectify the sital area of the property owned by her as 3268 square feet, and to acquire the entire portion of the petition scheduled property. You want the entire portion to be acquired?
Yes, your lordship.
Huh?
Yes, your lordship.
Why?
Since your lordship, it's the property which is acquired in middle of the property, your lordship. Once they have acquired that property, and it will not useful for either them, either for us also, your lordship.
If you're going to use a part of the property in the middle, ಅದು ಮಿಕ್ಕಿದ ಪ್ರಾಪರ್ಟಿ ಏನ್ ಮಾಡ್ಬೇಕು?
Because commercial rate ಕೂಡಿ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದಾರೆ ಸರ್.
Correct. Then you will say tomorrow that they will have to maintain a buffer. Building ಕಟ್ಟಂಗಿಲ್ಲ. Is it a vacant site?
Yes, your lordship. There is a commercial shed, your lordship. Car shed.
Vacant ಕಟ್ಟಂಗಿಲ್ಲ, building ಕಟ್ಟಂಗಿಲ್ಲ ಅಂತ ಹೇಳ್ತೀರಾ ನಾಳೆ ಬಫರ್ಗೆ. From 25 feet from the railway line, the buffer has to be maintained, isn't it? Tomorrow you will say maintain buffer, then they can't even use it. Get instructions whether you are interested to acquire the entire portion. Sorry, Dodadakam. Then counsel for the respondent number 2 and 3 is directed to secure instructions whether the respondent number 3 is willing to acquire the entire portion of the property belonging to the petitioner. List on so on.
And your lordship, there is an interim order.
Interim order granted as extent till the
Not to give effect to the award notice, your lordship.
Yes. Interim order granted as extent to the next date.
7 June. Serial number 20, Bhargav Ji.
Oblige, your lordship.
Bhargav Ji.
Date, madam.
Date.
Sir, date. Sale did execute ಮಾಡಿಲ್ಲ issue notice BDM.
They sought for quashing.
Yes, my lord. Only today issue notice BDM.
Who is this Krishnamurthy? Krishnamurthy ಯಾರಮ್ಮ? ಫೈಲ್ ಓದಿಲ್ವಾ? ಓದಿ ಫೈಲ್ ಓದಿ. ಪಾಸ್ ಓದಿ.
Serial number 21, R Gopal.
ನೀವೇ ಬರಬೇಕು. Don't go anywhere. ಫೈಲ್ ಓದಿ.
I appear for respondent number 2, my lords. I undertake to file wakalat for respondent number 2. Akshaya BM name to be printed.
What is challenged?
Lord, the annexure D, my lord. That 20 guntas of land of the petitioner was taken by the second respondent urban development authority. And my lord, they wanted this land for formation of 2-lane road in the urban area of Davangere. My lord, in lieu of my agreement, they decided, my lord, to give 4 sites in J.H. Patel extension. A resolution was passed to that effect. Another resolution confirming, my lord, for giving 4 sites were given, passed as per annexure C. Later, my lord, it was sent to government. Government rejects, my lord, their proposal as per annexure D, saying that, my lord, it is not possible to give 4 sites. 4 sites, my lord, were, my lord, I agreed and I gave, my lord, agreement also as per annexure B.
No, they used up your land.
Yes, used.
Will
And
receive
they-
instructions and file objections pertaining
Do
to this.
whatever, don't allot it to anybody.
It's already acquired, my lords.
Don't allot it to anybody.
Oblige.
Barkoli. The AGA for R1, Mr.
Akshaya BM.
Akshaya B.
BM.
So and so is undertakes to appear for respondent number 2. Office is directed to show his name in the cause list. In view of the assertions made in the writ petition, this court is of the opinion that until disposal of the writ petition, comma, the sites mentioned in the schedule to the writ petition shall not be alienated, encumbered or transferred or allotted by the respondent number 2 in favor of any person until disposal of this writ petition. Hence, the interim order as sought for by the petitioner is granted. Yes.
Serial number 22, Chetan AC.
Grateful.
Appearing for the petitioner, my lords. At the previous date of hearing, the matter was listed for preliminary hearing for disposal, my lords. The notice has already been issued to the respondents. This is the case of mandamus, my lords, directing the respondents to consider to grant pay compensation for the acquisition of the land. The petitioner's father's land was acquired. 1 acre, 1 acre was acquired, for which there was no notification, preliminary
Yes,
notification. Or
government consider Barcoli, the petitioner sought for it in the nature of mandamus to direct the respondent number 2, 3 and 4 to consider his representation dated 10/3/2026 and pay compensation in respect of the acquisition of 1 acre of land in survey number 8/4 situated at Cheelamanahalli, Gauribidnur Taluk, Chikbalapur district. The petitioner contends that his father was the owner of land bearing survey number 8/4 measuring 1 acre 37 guntas. 8/4 of Cheelamanahalli, Gauribidnur Taluk measuring 1 acre 37 guntas. Full stop. It appears that the respondents had acquired the 1 acre of land and formed sites which were distributed amongst the beneficiaries. Thereafter, the petitioner and the entries were made in the revenue records for the year 1989-90, by which it was indicated that a portion of the land was acquired for the formation of sites. The petitioner contends that no acquisition notification was issued and that the respondents 2, 3 and 4 had unlawfully taken over the land belonging to the petitioner and had formed sites. He therefore submitted a representation dated 10/3/2026 requesting the respondents 2, 3, 4 to pay compensation in respect of the acquisition of 1 acre of land. The petitioner contends that the said representation is not considered and therefore prays that a direction be issued to this court, to the respondents 2, 3 and 4 to consider the representation. The learned AGA, however, contends that the petitioner had lied low from the year 1989-90 and has filed a representation on 10/3/2026 claiming compensation. He contends that even before the respondents 2, 3 and 4 could apply their mind to the representation, the petitioner has approached this court within less than a month from the date of filing the representation. He therefore submits that no indulgence is warranted, no indulgence is to be shown to the petitioner. Next, I have considered submission made by the learned counsel for the petitioner and the learned AGA for the respondents. The petitioner has given a representation on 10/3/2026. His representation 10/3/2026. Ideally, the petitioner must have waited for the respondents 2, 3 and 4 to have acted on the representation. Full stop. Therefore, though the petitioner has hastily approached this court, yet the doors of this court cannot be shut on that ground alone. Since the respondents 2, 3 and 4 are under an obligation to consider the representation of the petitioner, a direction deserves to be issued to the respondents 2, 3 and 4 to consider the representation of the petitioner and pass appropriate orders. Hence, the writ petition is allowed. Respondents 2, 3 and 4 are directed to consider the representation of the petitioner and pass appropriate orders within a period of 3 months from the date of receipt of a copy of this order.
Much obliged.
Serial number 23.
The petitioners in this matter, my lords. My lords, the petitioners have challenged the demand notice that is issued by the second respondent BDA, my lords. My lords, the facts of this particular case is this, my lords. The petitioners are the owners of the property in possession which belongs to Doddabetta Halli, my lords. Later, my lords.
The
Yes.
betterment charges.
Yes, similar, my lords, as per serial number 17.
Good. AG is directed to accept notice for respondent number 1, Mr. Murugesh V. Charati is directed to accept notice for response 2 and 3. Since similar questions of fact and law are pending consideration before this court in several writ petitions where interim orders are granted staying the demand of betterment charges, an interim order as sought for by the petitioners in this writ petition deserves to be granted. Accordingly, the interim order as sought for by the petitioner is granted. Petitioners is granted.
Grateful, my lords.
Serial number 24, urgent. Serial number 25, D. Prabhakar.
I represent the petition in this case, my lords. Lord, the petitioner is the land loser, my lords.
Received copy, seek instructions to
Mm-hmm.
press on title for objections.
ಏನಿದು ಚಂದ್ರಶೇಖರ್ ಹೇಳಿದ್ದು
ಇದರಲ್ಲಿ ಅವರು ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಒಂಥರ ಇದೆ, ಪ್ರೇಯರ್ ಒಂಥರ.
ಆಹಾ.
ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಅಲ್ಲಿ ಇನಿಷಿಯೇಟ್ ಮಾಡಿ ಅಂತ ಕೇಳ್ತಾರೆ ಫ್ರೆಶ್ ಅಕ್ವಿಷನ್. Earlier they filed a writ petition. It was allowed to file a contempt. In the contempt they accepted and dropped the proceeding. Thereafter, liberty was granted for them to file a 18 application. Annexure A is the objection they filed. 2013 they kept quiet till 2026. Now they come on before your lordship. Even after Supreme Court judgment, 3 years, 90 days limitation. Even that's also over.
No, that is
also for the respondent number 1 seeks time to file objections. List on date.
2 weeks ago.
HM Saroja.
11th June. Serial number 26, Saroja HM.
15th or 16th.
HM Saroja. Good.
Serial number 26, Saroja HM.
Yes, Murugesh V. Charati is directed to accept notice for respondents. Respond number 1. What about this executive engineer, West Division, Mysore Road, Vijayanagara, Bangalore? You tavotire? HCGP is directed to accept notice for response 2 and 3. Then BWSSP na minor irrigation. Minor irrigation and groundwater development division. You tavotire? HCGP for 2 and 3.
Serial number 27, Somsekhar KH.
KH Somsekhar.
And the petitioners, my lord, are the site owners formed in Sarvan 53 of Srirampura village. And they have purchased my lord, in the year 1995 itself. And the paid betterment charges, my lord, to the concerned CMC. But some of the petitions constructed my lord, houses also. Lord, they filed a writ petition before this honorable court in earlier occasion.
Page
number 134, my lord. There is a clear direction to consider the representation of the petitioner based on the my lord Bonduram's case. Page number 34, annexure X.
Yes.
134. This is the direction issued by this my lord, this honorable court. After the my lord direction, I made a representation annexure Y.
Yeah, Nisarga Layout
They
Association.
are the formed an association, site owners. The my lord secretary my lord, the first petition herein. That secretary in the association is the first petition herein.
ಅಲ್ಲ ಇದೇನು ಅಸೋಸಿಯೇಷನ್ ಇದೆ ಇದ್ಯಾವುದು
ಅವಾಗ ಅಸೋಸಿಯೇಷನ್ ಇತ್ತು through association only they filed the site owners have filed the petition. Clear direction has been issued by the servant status quo also ordered. The last time kindly is annexure Y is the representation given by the petitioners and not and produce the copy of the order passed by the Honorable Court and request to delete my lord on the ground that my lord, the neighboring lands have been deleted. Based on the representation, my lord, the Additional land acquisition officer has taken submitted a report, Annex Z, my lord, page 146. She made a spot inspection, my lord, along with the other officers. And my lord, she come to a conclusion that, my lord, there is a neighboring lands have already deleted. This is comes under the, my lord, one of the parameter of the Bonduram's case. This has to be deleted.
This officer was the one who was caught. Dr. Sudha.
Sudha.
She was the one who was caught by the Lokayukta, accepting bribe or whatever.
I don't know.
ಅಲ್ವಾ?
ಇರ್ಬೋದು ಅಂತ ಕಾಣ್ತದೆ, ಕೇಳಿದ್ದೆ.
ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ, ಇನ್ಯಾರು ಗೊತ್ತಿರುತ್ತೆ?
ಇಲ್ಲ. And this report, my lord, has been submitted, my lord, to the BDA.
ಆಯ್ತು, ಅದಾದ್ಮೇಲೆ ಏನಾಗಿದೆ?
ಅದು ಕನ್ಸಿಡರ್ ಮಾಡಲ್ಲ.
Consider ಮಾಡಿಲ್ಲ, but then whether
This has to be, my lord, given effect to.
Correct, whether this court has passed an order
Annexure, my lord,
constituting that committee. Committee ಮುಂದೆ ಹೋಗ್ಬೇಕಲ್ವಾ?
ಅಲ್ಲ, ಕಮಿಟಿಗೆ ಯಾಕಂದ್ರೆ ಆಲ್ರೆಡಿ there is a report.
Correct, but now these reports have been debunked by this court. ಈ ರಿಪೋರ್ಟ್ಗಳನ್ನ this court has not accepted this report.
In my matter, my lord, this is the first time, my lord, I filed. Other
I appeared in all these matters. Either reports na another coordinate bench of this court refused to consider. This court constituted Justice Keshav Narayan committee. So therefore you have to go before the committee.
Keshav Narayan committee, my lord. Justice Keshav Narayan committee.
ಅಲ್ಲಿ ಹೋಗ್ಬೇಕು ನೀವು. ಬರ್ಕೊಳ್ಳಿ.
ಅಲ್ಲ, ಇದೊಂದು ರಿಪೋರ್ಟ್ ಅನ್ನ
HCGP has directed accept notice for R1, Mr. Murugesh Charati for 2 and 3.
Even, my lord, by seeing the, my lord, the notification itself, my lord, there is a neighboring lands have been deleted, except, my lord, this land.
Till the next date of hearing, the respondents are directed not to dispossess the petitioners from their respective properties. List on date put.
18th June. Serial number 28.
Manikanta.
Bit of mandamus, my lords.
What?
Lords, consideration of my representation with respect to Kempegowda layout, my lords, wherein the division bench of this honorable court had passed an order, my lords, at page number 333, issuing directions, my lords, if there is already layouts and the structures have been built, representations to be made to BDA.
No, but you have come after so many years.
No, my lords, I have placed my representation in the year 2024 itself. Now the problem is, my lords, without issuing notice or anything, some officials are threatening, my lords, we will vacate you from the property.
When was the judgment passed in Kempegowda?
2024, my lords, February 22, 2024.
That was judgment of the division bench?
Yes, my lords. After that, my lords, I gave representations, my lords.
You were a party to the writ petitions?
No, my lords.
Then? You're only those who are parties before the court are entitled to the benefit.
Since it would.
Oh, Mr. Everybody is misusing.
Justice A.S. Bopana.
If you have not come to this court, you are not entitled to the benefit.
But since every person in the shoes of the petitioners who had approached this honorable court, my lords, since it's in REM, I had given representations.
In REM ante hengagutte? This judgment is in personam to those persons who approach the court.
Yes, my lords.
Not to persons who have not come to the court.
But at page number 332, my lords.
Yes.
Those were the directions, my lords, which were issued.
Correct. It is only those who have come to this court.
Yes, my lords.
Not to those who are sleeping.
Since we are also, my lords.
Oh, no. Not to those who are sleeping. Without spending a pie, you want the benefit.
No, my lords, not so.
No, my lords, Sandra.
Let's
You did not engage an advocate. You did not come to the court. You want to piggy ride on somebody's order. How can you piggy ride on somebody's order? You are not before the court. This benefit is only to those persons who had come to the court. Yes, what will you do?
Let's in, I don't
ಏನ್
know
ಮಾಡ್ತೀರಿ?
whether in similar petitions, my lords, where notices were issued, they have approached the honorable court, my lords.
That is a mistake that we have committed. Keep on keeping the litigation alive.
We are only seeking for
Correct, only seeking allow. It is only for those persons who come to the court.
Let's in two matters, my lords.
Huh?
In two matters, my lords. Before this,
Could it?
whether they have approached or not.
Could you? No, this benefit cannot be given to those persons who have not come to the court.
Notices were issued, my lords, and based on the order passed by the Honorable Division Bench in Ittapil, my lords, having committee being constituted.
Right, Appa, I think these judgments, they were under the impression that you are parties before the division bench. We have been misled to believe.
No, my lords, I did not appear in those matters.
You do not know.
I didn't appear in those matters, my lords.
No. You're not entitled to the benefit.
I'll place judgments, my lords, to that effect.
Place whatever judgments you want.
Kind.
Place whatever judgments you want.
A date will be given.
Yavaga.
This next week, my lords.
Barkul. This petition along with the WP number 15232 of 2026, 8870 of 2026.
Same. Both are same.
Yavat ಬೇಕು?
Any day.
18.6.
Next. Great. Next week.
Serial number 29.
VV Vidyula appeal for the petitioner, my lords. My lords, in this matter, the CIT, then CITB Mysore, my lords, had issued a preliminary and final notification on 87, in 88.7 and 88, in respect of 2 acre 12 guntas of land, my lords, belonging to the father-in-law of the petitioner. My lords, general award was passed in the year 1989. My lords, till today, possession is not being taken and the award is not, the amount has not been deposited. Kindly see page 44, my lords, which is the Himbarha. Private layout of the entire land, 44, which is the endorsement issued by the authority. They say ರೂಪಾಯಿ 44,850ಗಳ ಭೂ ಪರಿಹಾರವನ್ನು ನಿಗದಿಪಡಿಸಿ ಅವಾರ್ಡ್ ನಿರ್ಣಯಿಸಿದ್ದು ಮುಂದಿನ ಭೂಸ್ವಾಧೀನ ಪ್ರಕ್ರಿಯೆ ಜರುಗಿರುವುದಿಲ್ಲ. ವಾಸ್ತುಸ್ಥಿತಿಯಂತೆ ಖಾಸಗಿ ಬಡಾವಣೆ ನಿರ್ಮಾಣವಾಗಿರುವುದು ಕಂಡುಬರುತ್ತದೆ. Now I have got 12 guntas, my lords, out of family partition in the year 1983-84, but I will not be given, my lords, any permissions or authorizations. So,
AGS directed accept notice for response number 1. Mr. TP Vivekananda for response 2 and 3.
my lords, not Mr. Vivekananda.
TP Vivekananda alva?
Beda, sir.
Mysore Urban Development.
Our Beda. Our Beda.
ಬೇರೆ ಯಾರಿದ್ದಾರೆ?
Poonam Patil is there.
Poonam Patil?
Yes, please.
Ms. Poonam Patil, Mrs. Poonam Patil is directed to accept notice for response number 2 and 3. Since the endorsement at annexure
G1, G and G1.
Annexure G and G1 shows that though an award was passed on
Award was passed, my lords, on 11/1/1989.
On 11/1/1989, the compensation is, no steps are taken thereafter to pay the compensation, an interim order as sought for by the petitioner deserves to be granted. An interim order directing the respondents not to disturb the possession of the petitioner in the property described in the schedule to the writ petition deserves to be granted. And accordingly, the respondents are directed not to disturb the possession of the petitioners in the property described in the schedule to the writ petition till the next date of hearing. List on date.
Next. Serial number 30, Varadarajan MS.
Yes, MS Varadarajan.
That's the question that I have raised. Minutes, if a private layout is formed, the roads formed in that private layout vests in the authority after the relinquishment deed is executed. Therefore, the developer or the owner cannot now close that road from public access. That is what the division bench of this court has also held.
Yes.
If they kindly turn to that map sketch that I have produced, they are approved.
Compound kattidara ilva?
ಕಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. One portion ಅಲ್ಲಿ ಕಟ್ಟಿದ್ದಾರೆ. ಅದು ಡಿಮಾಲಿಷ್ ಮಾಡಕ್ಕೆ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ 1 2 3
ಕಟ್ಟಿಬಿಟ್ಟಿದಾರಲ್ಲ ಆಗ್ಲೇ.
ಅಲ್ಲ ಅದಕ್ಕೆ ಅದನ್ನ ತೆಗ್ಸಕ್ಕೆ ಅದು ಕಟ್ಟಿದ್ದಾರೆ.
So therefore you take out notice by interim order we cannot.
ಅಲ್ಲ ಇಂಟ್ರಿ ಮಾಡುವ ಇನ್ನೊಂದು JK ಅಂತ ಇದೆಯಲ್ಲ ಅಲ್ಲಿ ಕಟ್ಟಿಲ್ಲ ಇನ್ನು ಅಲ್ಲಿ ಕಟ್ಟಕ್ಕೆ ಹೋಗ್ತಾ ಇದ್ದಾರೆ.
JK
A B ಇರೋ ಜಾಗದಲ್ಲಿ ಆ ಸ್ಕೆಚ್ ಅಲ್ಲಿ ಕಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಎಷ್ಟು ಲೇಔಟ್ ಪ್ಲಾನ್ ಅಲ್ಲಿ ತೋರಿಸಿದ್ದೀನಿ ಅವ್ರು ಎಲ್ಲಿ ಕಟ್ಟಿದ್ದಾರೆ ಅನ್ನೋದು ಆ ಎ ಬಿ ಅಂತ ತೋರಿಸಿದ್ದೀನಿ ಅಲ್ಲಿ ಕಟ್ಟಿದ್ದಾರೆ ಅದನ್ನ ರಿಮೂವ್ ಅಲ್ಲೇ ಡೈರೆಕ್ಷನ್ ಕೇಳ್ತಾ ಇದ್ದೀನಿ.
ಅಲ್ಲೇ ನಿಮ್ಗೆ ಆಕ್ಸೆಸ್ ಗೆ ತೊಂದರೆ ಆಗಲ್ವಲ್ಲ?
ಅಲ್ಲಿ ತೊಂದರೆ ಆಗಿದೆ ಅಲ್ಲೇ ನಮ್ಮ ಪ್ರಾಪರ್ಟಿ ಬರೋದು.
ಇಲ್ಲಿ
71/5 ನಮ್ದು ಅಲ್ಲಿ ಬರುತ್ತೆ ಅಲ್ಲಿ ಕಟ್ಟಿದ್ದಾರೆ ಅದಕ್ಕೆ ಎಂಟ್ರಿ ಮಾಡಿರಲಿಲ್ಲ ಫೈನಲ್ ಆಗಿ ಕೊಡಬೇಕಾಗುತ್ತೆ ರಿಲೀಫ್. ಬಟ್ ಆನ್ ದಿ ರೈಟ್ ಹ್ಯಾಂಡ್ ಸೈಡ್ JK ಅಂತ ತೋರಿಸಿದ್ದೀನಲ್ಲ
71/5 ಅಂತ ಕಾಣ್ತಿಲ್ವಲ್ಲ ಅಲ್ಲಿ?
ಇದೆ
ಇದೆ ಅಂದ್ರೆ
ಅಲ್ಲಿ F ಅಂತಿದೆಯಲ್ಲ ಅದ್ರ E ಅಂತಿದೆಯಲ್ಲ ಅದ್ರ ಕೆಳಗೆ ಇದೆ.
JK ಇರೋದಿಲ್ಲಿ F ಇರೋದಿಲ್ಲಿ
ಅಲ್ಲ AB is that southern boundary of the layout. ಅದರಲ್ಲಿ CD EF GH ಆ ಮೂರು ಆ ರೋಡ್ ತುದಿ ಅಲ್ಲಿ ಕ್ಲೋಸ್ ಮಾಡಿರೋದು ಅವರು. ಇನ್ಫ್ಯಾಕ್ಟ್ ದೇ ಹ್ಯಾವ್ ರೇಸ್ ಪುಟ್ ದಿ ಕಾಂಪೌಂಡ್ ಅಲಾಂಗ್ ದಿ ಲೈನ್ AB.
ಟೇಕ್ ಔಟ್ ನೋಟಿಸ್ ಬರ್ಕೊಳ್ಳಿ.
ಅದು ನೋಟಿಸ್ ಕೈಂಡ್ಲಿ ಕಮ್ ಟು ದಿ ರೈಟ್ ಹ್ಯಾಂಡ್ ಸೈಡ್ ಇನ್ ದಟ್ ಸ್ಕೆಚ್ JK ಅಂತ ತೋರಿಸಿದೇನಲ್ಲ.
We do not know whether they put up construction or not.
ಅಲ್ಲ JK ನಲ್ಲಿ ಹಾಕಿಲ್ಲ.
AG is directed except notice for respond number 1. Murugesh Charati for respond number 3, 4. Emergent notice to respond number 2 and 5. List down on date ಕೊಟ್ಬಿಡಿ
18/6
for consideration of interim prayer.
Serial number 31, Doreraj BH.
Doreraj. Yes.
I appear for the petitioner. Petitioner participated in an e-auction held on 11/12/2025, which is at annexure B.
Yes.
Page number 15. And petitioner was declared as the highest bidder. Advice notice was issued at annexure D.
Yes.
And 25% of the bid amount was to be directed to pay. Petitioner paid. Subsequently, annexure D was issued. Then petitioner was directed to pay the entire cost. That is around 4 crore 13 lakhs came to be paid under annexure E, page number 19. Thereafter, my lord, a petitioner requested by giving a letter dated 7th February 2026 at page number 20. Niveshana correct idya anta kellikke. At annexure G, page number 21. I may read, my lord. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಈ ಹರಾಜು ಅಧಿಸೂಚನೆ ಸೋ ದಿನಾಂಕ 31/10
ಟೇಕ್ ಔಟ್ ನೋಟಿಸ್ ಬರ್ಕೊಳ್ಳಿ.
My lord, they are planning to now do the re-auction and allot it to somebody else.
On what ground?
My lord, saying that I have not, they're saying now I have paid entire thing, yet they are not coming to do the registration. They have asked me to give the entire sale deed ready. Draft sale deed also I have submitted, yet after 2 months after so and so forth, they are not coming for registration. Now they are internally, I come to know they are going for re-auction. My only request is to stay any kind of re-auctioning
So what ground they want to go for re-auction?
My lord, which they have not given any reply to my representations also, my lord. Now I am at nowhere to go except come before this honorable court. I have given 3 representations. No reply have been given. Annexure A and annexure at page number 33 and page number 32. Annexure N and annexure P. No replies have come. Internally, BDA, I go to meet officers, they say they're looking to re-allot to somebody else. They don't give any return replies.
Mr. Murugesh Charati is directed to accept notice for respondent. Till the next date of hearing, the respondent is restrained from auctioning or re-auctioning or allotting or selling to any person site number 559 bar A at Sir M. Vishwesharaya Layout, 5th block, Bullalu, Bangalore 560110. Let's list down on date.
Much obliged. 19 June. For further hearing matter, serial number 32, Jaitra J. Narayan.
Yes, where is the memo?
Kindly pass over memo is
Said you will file a memo.
for withdrawal of the first matter, Your Lord.
A memo is filed by the learned counsel for the petitioner to withdraw this petition. The memo is taken on record and the petition is dismissed as withdrawn. Yes. List 32.1 tomorrow.
Your Lordship, next, any date next week, Your Lordship.
Next Thursday, good. Next Thursday. Thursday, Rajana? Next Thursday.
Much of it. Your Lordship, interim order.
Interim order is extended till the next.
Much of it.
Find out ಇದು ಜಸ್ಟಿಸ್ ಡಿ ಕುನ್ ಅವ್ರು ಇದಾರ ಇಲ್ವಾ ಇದು ಊರಲ್ಲಿ ಜಸ್ಟಿಸ್ ಮೈಕಲ್ ಡಿ ಕುನ್ ಅವರು ಊರಲ್ಲಿ ಇದನ್ನ ಕೆನಡಾಗೇನೋ ಹೋಗ್ತೀವಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ರು ಜಸ್ಟ್ ಫೈಂಡ್ ಔಟ್ ಇಫ್ ಈಸ್ ದೇರ್
I'll place it on. Great.
For final hearing matter, serial number 33, Shaila Kumari.
This matter, my lords, file has been returned. By next week, they will ensure somebody appears in this matter, my lords.
Final hearing, bro.
I understand.
Nobody is arguing any final hearing matters.
Reasons we.
The learned counsel for the respondent seeks time on the ground that the file which was entrusted to him is taken away by the respondent. And says last chance list on so and so. It is made clear no adjournment should be granted on the next day.
I'll inform.
Do whatever you want.
Serial number 34, Karthik V.
Karthik V.
Respondent to my lord. Kindly pass over, my lord.
You are for Karthik.
Respondent to my lord.
Girish.
Girish Energy.
Pass over.
Serial number 35, urgent. Serial number 36, Prakash MH.
MH Prakash. Mr. Hiremat.
Your lordship seek for short accommodation. Senior is unwell, your lordship.
ಹಂಗೆ ನೋಡ್ರಿ ಎಷ್ಟೆಷ್ಟು ಅಡ್ಜಮೆಂಟ್ ತಗೋತಿದ್ರ ಅಂತ 10 ಮ್ಯಾಟರ್ಸ್ ಸೀರಿಯಲ್ ನಂಬರ್ 33 to 41 8 ಮ್ಯಾಟರ್ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಬಂದಿದೆ 8 ಮ್ಯಾಟರ್ ಅಲ್ಲಿ 1 2 3 4 5 6 7 ಮ್ಯಾಟರ್ ಅಡ್ಜಮೆಂಟ್ ತಗೊಂಡಿದ್ದೀರಿ ಬೆಳಿಗ್ಗೆ 10:30ಗೆ ಈಗ ಒಂದು ತಗೊಂಡ್ರು 7 ಆಯ್ತು ಇನ್ನು ಒಂದು ಮ್ಯಾಟರ್ ಇದೆ.
Senior is unwell, your lordship.
What is this? Learned counsel for the petition seeks time on the ground that the arguing counsel is unwell. As the last chance list on so and so, it is made clear no adjournment will be granted next date of hearing.
19 June. Serial number 37, Girish GN.
GN Girish. Murugesh Charati. GN Girish.
Some week after next month, I have some personal.
Next week, ಆಗ್ತೀನಿ ಮಾಡಂಗಿದ್ರೆ ಮಾಡಿ ಇಲ್ಲ ಅಂದ್ರೆ ಬಿಡಿ. Learned counsel for the petitioner seeks time as so and so same order list on so and so.
Serial number 38, urgent. Serial number 39, Rajendra MS.
Murugesh Charati.
Lords, petition is education society, my lords. Lords, for the purpose of construction of the school, we sought for the allotment of CA site, my lords. In the year 1978, my lords, a portion, plot number 40 was allotted. And 1986, my lords, another plot number 40P was allotted, my lords. We put up the construction and we are running the institution. And the lease deed was executed, my lords, for a period of 30 years. for a period of 30 years, my lords, from 1978 to 2008 and 1986 to 2016, my lords. And the payment of lease was, my lords, kindly come to page 48, my lords. Lease deed, my lords. If my lords kindly comes to class number 4, my lords. The ink page is at 56 at page 57, my lords. The lease period of 30 years prescribed in this agreement in the first instance may be renewed, subject to the renewal for a period to be determined by the lessor on payment of the said nominal rent of rupees 2 per annum or for any other amount then to be fixed by the lessor by a separate deed. My lords, we were paying the annuity based on the lease deed, my lords. And my lords, 2008, the lease was expired. We filed an application seeking for renewal. Page 117 is the renewal application, my lords. Annexure Q, my lords. When we sought for the renewal, till today, my lords, no reply. And in the 136, my lord, the second property, another property we sought for renewal, till today, no reply, my lords. And all of a sudden, my lords, page, if my lords kindly come to page 140.
Yes.
They issued an endorsement saying that without any bifurcation or without any this one, my lords, they demanded an amount of 5.43 crores for the renewal of the lease. That too without, my lords. In fact, if my lords kindly come to page class 4, my lords, it prescribes a separate deed to be executed after a period of 30 years. Till today, not been done.
Now, what does the rule say? After expiry, what should be the rate?
My lords, the lease itself provides for the same amount for another period of 30 years, my lords. If my lords kindly come to the lease deed, is the specific lease term. ಇದ್ರಲ್ಲೇ ಬಂದೆ ತಾವು ಇದ್ರಲ್ಲೇ ಕಾಣುತ್ತೆ ಪೇಜ್ 50 ಅಲ್ಲೇ
30 years prescribed also may be renewed, subject to renewal for a period to be determined by the lessor on payment of the said nominal rate of rupees 2 per annum or for any other amount then to be fixed by the lessor by a separate deed.
By a separate deed.
Now, what do the rules say? Rules code, allotment of civic community site rules. BD allotment of civic community site rules. BD Act ಕೊಡಿ ಅದರಲ್ಲೇ ಇರುತ್ತೆ. BD Act. ಇದರಲ್ಲಿ ಇದ್ದಂಗಿಲ್ಲ. Yes. Please come to rule 8.
Rule 8 of the allotment of site rules, my lords.
Civic community site rules. Lease amount of the of the CA sites allotted to the institutions.
Comes for renewal of the lease, the guidance value was taken into consideration. Based on that, but the certain fixations were made to each area, saying that this would be the lease amount, percentage of the lease amount which will be they'll have to pay, and not they'll have to continue the lease amount. Once they make the lease amount, pay the lease amount, the continuation of the lease period.
Is that the basis for extending the term of the lease for all civic community sites? That is a basis? Where is the resolution of the authority?
In 2011,
Really the copy? Yes, Mr. If they applied the rule uniformly to everybody within.
Not subjections ಏನು ಹಾಕಿಲ್ಲ ಏನು ಕೊಡ್ನಿಲ್ಲ ಇದುವರೆಗೂ as on today.
Have you deposited any money?
My lords, 35% I have deposited. My lords, subject to my lords have granted the interim order. Subject to deposit of 35% of the 2.3 crores I have deposited, my lords.
2.3 crores.
Please.
ಮಿಕ್ಕಿದ ಕಟ್ಬಿಡಿ ಕ್ಲೋಸ್ ಆಗುತ್ತೆ. See, the lease deed doesn't say that the renewal should be on the same terms or any other amount then to be fixed by the lessor by separate deed.
ಇದೆ. That is there.
If they have adopted a uniform principle.
ಅದುವರೆಗೂ ಯಾವುದು notice because they have not mentioned anything about those things, my lords.
Yes, Gaurav, BDA.
I'll put it on record. Sorry. What had happened is this.
ಒಂದು ಕೇಸಲ್ಲೂ ಯಾರು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಲ್ಲ ಅಂದ್ರೆ ಏನು ವಾಟ್ ಇಸ್ ದಿಸ್ ವೆರಿ ಸಾರಿ ಸ್ಟೇಟ್ ಆಫ್ ಅಫೇರ್ಸ್.
Sorry, but these files were not all this. What happened is all these education institutions. Sorry to say this, are run by all this
Politicians or whatever.
ಇಲ್ಲೊಂದು ಬರ್ತಾರೆ ಸರ್ಕಾರಕ್ಕೆ ಒಂದು ಕೊಡ್ತಾರೆ ರೆಪ್ರೆಸೆಂಟೇಟಿವ್. ಇಲ್ಲಿ ವೈಲೇಷನ್ 224% of violation in the building which has been done.
We are not concerned with that.
ಅದಕ್ಕೇನು ಎಲ್ಲ ಪೆನಾಲ್ಟಿ ಆ ತರದ್ದು ಎಲ್ಲಾನು they will have to pay all those things. That has been taken note of. Look, I received the file today. I'll put it on record. I have there tomorrow also. I'll put it on record.
The learned counsel for the respondent number 1 and 2 seeks time to file objections. List on Thursday.
Monday
Monday ಇಲ್ಲ. Monday, Tuesday, Wednesday is land acquisition day.
Next Thursday senior.
Thursday.
Next Thursday.
ಅದೇ next Thursday. ಇವತ್ತೇ Thursday ಅಲ್ವಾ?
Sorry, ಅದೇ next Thursday. Sorry, my lords.
Yes.
Not sir. Mr. Vivek name may be shown in the cause list, my lords. ಅದು ತಪ್ಪಾಗಿ ಇದಾಗಿದೆ ಒಂಚೂರು.
But whether is entered appearance.
ಅದೇ ನಾವೇ ಅದೇ Mr. Vivek has filed the wakalat actually.
Office is directed to show the name of Mr. Vivek Kolla as the counsel for the petitioner in the cause list.
Kindly oblige, my lords.
Yes. 41.
40 urgent, serial number 41.
Gamesh.
41 Sangamesh RB.
Yes. Unni Krishnan.
BDA.
Unni Krishnan is no longer in the panel.
Unni Krishnan sir ilva.
PDA.
Unni Krishnan either.
Because he has appeared in this
Everybody is on the panel. What has happened is out of 5 names which are mentioned.
No, that's okay.
Bari notice ತಗೊಂಡು BDA ಗೆ
Unni Krishnan idara panel.
Either. I'll inform him.
Yes. Yes, Sangamesh.
My lord, I have sought for a mandamus in this matter. That's where the petitioner claims that lords he is the owner of land survey number 82/6. Lords, the total measurement is 1 acre 26 guntas of Tanisandra village, lords. Lords, this is earlier, lords, it was notified in the preliminary notification, but final notification, lords, it was not included. So it is out of equation, lords. Now, lords, the PDA has formed a layout by forming a sketch where, lords, there was no site formed for the approach road to provide to this land, lords, which is a landlocked, lords. Now, suddenly, lords, they form one site in between to block my road, lords. Your lords will find that sketch, lords, at annexure E, lords. I will, lords, first, this is a hand sketch made by me, lords, for easy reference. Annexure E, lords, page 15, lords. 16, lords.
15 or 16?
16, this is a hand sketch, my lords. I will just show that, then I'll take a lordships to the BDA sketch. This is the hand sketch, computerized hand sketch.
Ah,
Your lordships will find, my lords, this 82/6 is my land, my lords.
ಇದು 82/3B ಅಂತಿದೆ.
ಅಲ್ಲ, 82/6 ನನ್ನ land. I have stated in the petition.
No, no. 82/6.
ಕೆಳಗಡೆ ಇರೋದು, the vacant land, my lords, which is out of acquisition.
So they want to
I'm referring to this, my lords. The
164A ಮಾಡಕ್ಕೆ ಟ್ರೈ ಮಾಡ್ತಿದ್ದಾರಾ?
ಆ 164A ಅಂತ ಒಂದು ಇನ್ಸರ್ಟ್ ಮಾಡೋದಕ್ಕೆ ಟ್ರೈ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. And your lordships may kindly see, in fact, the road has already been formed and used by me for quite long time. Page 18, my lords, may kindly see. There they have themselves put all the drainage lines and even the hole which directly enters my property, my lords.
ಎಲ್ಲಿದೆ ಡ್ರೈನೇಜ್ ಎಲ್ಲಿದೆ?
ಅಂದ್ರೆ ಆ ಕಡೆ ಈ ಕಡೆ ಡ್ರೈನ್ ಮಾಡಿದ್ರೆ ಅದು ಮುಚ್ಕೊಂಡಿದೆ, ಇದು ಮಾಡಿರೋದ್ರಿಂದ.
Annexure G ನಲ್ಲಂತೂ it looks like some revenue layout.
Revenue layout ಅಂದ್ರೆ your lordships will find that gate kind of a thing where the compound is there. Inside that is my 1 acre land, my lords. Now ಈ ಕಡೆ ಪಕ್ಕದಲ್ಲಿ ಒಂದು ಮನೆ ಇದೆ. This is 164. Now the portion which is a road there, my lords, now they want to make a site.
Yes, Mr. Unni Krishnan.
Senior is engaged in other court in short date.
Short date ಎಲ್ಲ ಕೊಡೋದಿಲ್ಲ.
Please, your lordship.
No, how can you close a road, Mr., which is being used by the residents? How can you close the road?
In fact, your lordships may kindly see page 15, my lords. ಅಲ್ಲೂ 166, 65, 64, 63 ಅಂತ ಬರುತ್ತೆ. ಸಡನ್ ಆಗಿ ಒಂದು ಸೈಟ್ ಅನ್ನ ಮಧ್ಯದಲ್ಲಿ 164A has been.
Yes, Unni Krishna.
Short accommodation ಬೇಕು.
Hey,
Not ಅಲ್ಲ ನಾನು ಪ್ರಿಪೇರ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. I'm sorry, that's the truth.
correct, Mr.
Last time ನಾನು ಮಾಡಿದ್ದೆ.
No lawyer is
ಅಲ್ಲ ಇವತ್ತೊಂದು
everybody from the last 1 week I've been saying that everybody is taking the court for granted.
Monday I'll go.
No, you're taking the court for granted.
Sorry,
Everybody is coming for an adjournment, seeking an adjournment.
ಇವತ್ತು ಸ್ವಲ್ಪ
ಆಯ್ತು, ಒಂದಿನ 2 ದಿನ ವೆಕೇಶನ್ ಆದ್ಮೇಲೆ ಏನೋ withdrawal symptoms, I can understand. But Counsel for the respondent number 2 seeks time as the last chance list on so and so made clear that no adjournment shall be granted on the next date of hearing.
For preliminary B group matters, serial number 42.
ಯಾವತ್ತು sir?
HN Basuraj, 11th.
Very good.
HN Basuraj, Sachin BS.
I'm filing a memo for reporting death of petitioner, my lords. File a necessary application. Reporting death of the sole petitioner, my lords. He died on 2/3/2025.
You're filing the application?
No, my lords. I'm filing the only memo, my lords.
So what do you want to do?
I'll file appropriate application, my lords.
Learned Counsel for the petition submits that the petition has expired, and when did he die?
2/3/2025, my lords.
Died on 2/3/2025. In that way of the matter, this petition stands awaited. File an application.
Please,
Yes.
Serial number 43 and 44 are urgent. Serial number 45, Deepa J. 45, Deepa.
My lord, appearing for the petition in the matter, my lord, we have received NOC Wakalat from the present council. Kindly list the matter in the next week, my lord. We'll argue the matter in the next week.
The request is made for an adjournment. Last chance list on so and so made clear no adjournment will be granted next date of hearing.
Interim order,
Interim order granted to the next date of hearing. Yes.
46, M. Narayan Bhatt.
Appear for the petitioner. My lord,
Girish.
Short accommodation, my lords.
Huh?
Short accommodation.
Short accommodation. Huh. ನೀವು ರೆಡಿ ಇಲ್ವಾ?
ನಾನು ರೆಡಿ ಇದೆ.
ನೀವು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿಲ್ಲ?
ಇಲ್ಲ ಸರ್, ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ.
ಇನ್ನ ಎಷ್ಟು ವರ್ಷ ಬೇಕು?
ರೆಡಿ ಇದೆ ಸ್ವಾಮಿ, ಸಿಗ್ನೇಚರ್ ಬೇಕಾಗಿತ್ತು ಹಂಗೆ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ.
ಪಾಪ ಇವಾಗ 8 ವರ್ಷ ಆಗಿದೆ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿ, ಇನ್ನ ಎಷ್ಟು ವರ್ಷ? ಹೌ ಮೆನಿ ಮೋರ್ ಇಯರ್ಸ್ ಯು ನೀಡ್ ಟು ಫೈಲ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್? Counsel for the response 2 to 4 seeks time to file objections. List on sounds.
11th June.
Next week, my lord.
47 urgent. 11th. Serial number 47 and 48 are urgent. Serial number 49, Hanumantraya D.
D. Hanumantaraya, M.V. Charati.
47 is sorry.
Huh?
47. Serial number 47, Samir SN. Samir.
Petitioner. What is NOC ವಕಾಲತ್ ಕೊಟ್ಟಿದ್ದೀವಿ ಸರ್ ಮೆಮೋ
ಯಾರಿಗೆ?
ಆಫ್ ಪೆಟಿಷನರ್
Who are you?
ಪೆಟಿಷನರ್ ಮೇಲೆ
What's your name?
ಸಮೀರ್ ಮೈ ನೇಮ್ ಇಸ್ ಅಶೋಕ್ ಕುಮಾರ್ ಕನ್ನಡ
ಯಾರು NOC ಕೊಟ್ಟಿದ್ದಾರಪ್ಪ? Sabir has given NOC.
ಎಸ್ ಮೈ ಲಾರ್ಡ್
To whom? Who has entered appearance? ಬಸವರಾಜಪ್ಪ.
ಸಮೀರ್ ಎಸ್ ಎನ್ ಎಸ್ ಮೈ
ಬಸವರಾಜು ಮತ್ತೆ ಸಮೀರ್ ಒಂದೇ ಆಫೀಸಾ?
ಒಂದೇ ಆಫೀಸ್
ಹಾ?
ಒಂದೇ ಆಫೀಸ್
ಯಾರ್ಯಾರು?
ಸಮೀರು
ಆಮೇಲೆ
ಬಸವರಾಜಪ್ಪ
ಒಂದೇ ಆಫೀಸಾ? ಯಾವ ಕೊಟ್ಟಿದ್ರಿ NOC? NOC ಕೊಟ್ಟು ರಿಟೈರ್ಮೆಂಟ್ ಮೆಮೋ ಹಾಕಪ್ಪ.
ಕೊಡ್ತೀವಿ ಸರ್ ನೆಕ್ಸ್ಟ್
ಯಾವ ಕೊಡ್ತೀವಿ?
ಮಾಡ್ತೀವಿ ಒಂದು 10 days ಟೈಮ್ ಕೊಟ್ರೆ ನೆಕ್ಸ್ಟ್
10 days ಎಲ್ಲ ಕೊಡೋದಿಲ್ಲ.
It was 47.1. I have filled the.
What to do? It's a connected matter. I can't disconnect both the matters. Learn counsel for the petition seeks time to file a memo of retirement. List on sounds.
Lots in 47, maybe copies are not served till now.
Yes, copy ಅಂತ ಕೊಟ್ಟಿರೋದು ಕೊಡಪ್ಪ, ಕಾಪಿ ಕೊಡು.
11th June.
List on
11th June.
Number 48, urgent. Serial number 49, Hanumantraya D.
D. Hanumantraya.
Petitioner, my lord. The preliminary
Charati.
notification on 12/1991, my lord.
Charati, idhar.
The final notification on 24/1/1996, my lord. We are voluntarily surrendered the site, land, my lord. Thereafter, my lord, the BDA was allotted incentive sites. My lord. Thereafter, my lord, after the sale deed which was executed on September 27th, 2018, my lords, at annexary page number 45, my lords. In the said sale deed, my lords, we paid 6,04,960 rupees, my lords.
Only one site was
Yes,
allotted
only
to
one
you.
site, my lords. That is 30/40. Thereafter, my lords, after execution of the sale deed, my lords, at
So
annexary,
the area acquired?
1 acre, my lord.
1 acre.
1 acre.
So you got 40/60.
No, my lords, 30/40.
30/40.
30/40, only 30/40.
Ah.
Kindly, my lords, come to annexure at page number 18. The endorsement issued ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ತಮಗೆ ಪ್ರಾಧಿಕಾರದಿಂದ ನಾಗರಬಿಯ ಎರಡನೇ ಬ್ಲಾಕ್ ಬಡಾವಣೆಯಲ್ಲಿ 30-40 ಅಡಿ ಅಳತೆಯ ನಿವೇಶನ ಸಂಖ್ಯೆ 448 ಹಂಚಿಕೆ ಮಾಡಿ ಹಂಚಿಕೆ ಪತ್ರವನ್ನು ನೀಡಿರುವುದು ಸರಿಯಷ್ಟೇ.
ಬಾಕಿ ನಿವೇಶನ ಮೌಲ್ಯ ರಿಮೈನಿಂಗ್ ಅಮೌಂಟ್ ದೇ ಆರ್ ನಾಟ್ ಪೇಡ್.
54 lakhs 70.
ಡೆವಲಪ್ಮೆಂಟಲ್ ಚಾರ್ಜಸ್.
What was the incentive scheme? Instead of compensation, you are giving a site.
Yes, my lord. Developmental charges has to be paid, my lord.
Huh?
Development charges
Why?
has to be paid, my lord.
Why? It is an incentive site that you are going to give him. It is an incentive site that you are kodi ellida, the incentive scheme kodi ellida. Kodi bida. Yes, Ajay Kumar, where is that incentive scheme?
But under the incentive scheme rules, my lords, it is where the landowner voluntarily surrenders and cooperates with the acquisition, my lords. As incentive, my lords, they are offered a site which they can, my lords, instead of they turning up in the queue and seeking for an allotment, my lords, we will allot them a site, my lords, but they'll have to bear the charges.
Oh, the what charges?
Please.
The compensation will be utilized.
It's not compensation.
Instead of the,
It's
the
not
compensation amount.
Please, no, addition to the compensation, my lords.
In addition to the compensation.
Addition to the compensation, my lords, as an incentive, my lords, so that they cooperate with the acquisition. Please.
Rule 4.1,
Rule 4.1, it's BDA Incentive Scheme Rules 1989.
Incentive scheme rules.
Please.
ಇದ್ರೊಳಗೆ ಇದೆಯಾ?
ಇದೆ. It's the old layouts and all these
Conditions of allotment.
Rule 4. There, Malaj. Let's have that. The allotment under Rule 3 shall be subject to the following conditions. Allottee shall be liable to pay the value of the site fixed by the authority and shall also be liable to pay other charges which the authority may levy in this behalf from time to time. The site shall be allotted at the discretion of the authority, but preferably in the layout for the formation of which the land is acquired. And if such allotment in the said layout is impracticable, in any other layout formed subsequent to the said layout.
Yes.
The allottee shall not be entitled to get allotment under these rules unless he proves to the satisfaction of the authority that he has got absolute title or the same. So it's next month. The total land, total extent of land allotted in Rule 3 together with the land already.
ಸೇಲ್ ಡೀಡ್ ಎಲ್ಲ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ರಲ್ಲ.
Already the
ಸೇಲ್ ಡೀಡ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ಆದ್ಮೇಲೆ ಔಟ್ರೈಟ್ ಸೇಲ್ ಬೇಸಿಸ್
we paid the value of that site also.
Please wait, boy.
Sorry, madam.
Please,
execute ಮಾಡಾದ್ಮೇಲೆ why are you, how can you demand?
4A.
ಓದು. Please come to the last 4F.
Please, allotment shall be on outright sale basis. The allottee shall meet the necessary registration other expenses for obtaining the sale deed.
Yes. So 6 ಲಕ್ಷ ತಗೊಂಡಿದಿರಲ್ಲ, ತಗೊಂಡು ಸೇಲ್ ಡೀಡ್ ಬರ್ಕೊಟ್ಬಿಟ್ಟಿದಿರಲ್ಲ. How can you demand another 50 lakhs from him?
54 lakhs.
You just check and
huh?
Kindly pass on.
Kindly have it on Monday, madam.
Mister, when the court is with you, you should sail with the court.
You just come back.
50.
50?
Yes, sir.
15 is same, huh?
Same, madam.
50 is pass over.
Serial number 51. Leehapi Devadiga.
Appearing for the petitioner, my lord. I seek time, my lord, for hearing.
What time, madam? Why?
My lords, any day next week, my lord. My
No,
senior
please
is
file
out
the
of
amended
station.
cost title. Please amend the cost title.
Yes,
Please
ma'am.
file an amended cost title now, today. Do
Yes,
it today.
yes.
Pass over. Yes.
Serial number 52 adjourned. Serial number 53. Nagaraj Rao case.
Nagaraj Rao case.
Please. They are asking for reconveyance of a site. Which they are trying to now say, my lords, it corresponds to a BDA site. They say they had purchased this site, and they are saying that it should have been considered to be part of the reconveyance scheme.
The scheme with reconveyance.
I have even produced the entire list of the sites which the society had requested for.
Particular layout. Please. Reconveyance scheme was applicable to this layout also.
For this particular layout, my lords, the society having requested for reconveyance of their particular members, they gave a list for those. That list, my lords, it has been.
Where is the application of the reconveyance scheme to this village or this layout?
That specific, this one I'll produce, my lords. What I have produced before the honorable court right now, my lords, is the statement showing the proposals.
Ajay Kumar, I need to know whether the reconveyance scheme is made applicable to this layout also.
Please, I
if the reconveyance scheme is made applicable, just because the society has not mentioned this man's property, can his right be taken away?
That is one part of it. Second part is the particular site which is being referred to, site number 260. Lords, in fact, it corresponds to a different site, Annexure R1, if my lords may have. That was in fact part of some other person, my lords, one yes, Nanjundaya. ಅದರಲ್ಲಿ ಅವಾಗ that was site number 1, 2 and 3. So this site number 260 corresponds to that particular site.
But what is the site number?
But this site number which
Annexure
they are,
R1 ನಲ್ಲಿ
pardon me, let's.
Annexure R1 ನಲ್ಲಿ
Please.
what is that site number?
Your site number 3 which is mentioned over there, my lord, corresponds to the site number 260.
ಹೆಂಗಾಗುತ್ತೆ? Whether R1 is also allotted by the society?
Please.
Huh? Nanjundaya.
Please.
Survey number converted into already.
I'll get that one. I'll get that file itself.
Everybody is doing this. I'll get it. I'll see it. And ನೋಡ್ತೀನಿ
Ask the
ಕೇಳ್ತೀನಿ
question,
ಮಾಡ್ತೀನಿ. Then why should we list the matters at least?
Let's may have this matter by the Friday.
The learned counsel for the respondent petitioner is absent. The learned counsel for the respondent number 2 seeks time to place on record whether the layout in question was covered under the reconvened scheme. List on Thursday.
Thus, please.
Number 54, HR Anand Krishnamurthy.
HR Anand Krishnamurthy. Basavaraj HT.
I represent the petitioner.
Yes.
Short question is survey number 39/3 and 39/4 of Kacharkanahalli village. I say
39/3.
39/3 and 39/4 of Kacharkanahalli village. According to me, I have only a small site in 39/4. I was called upon to appear before the BDA. I sought for instructions. I made an application of the RTI. The last time I kindly turn to Annexure K. Annexure K. Page 75.
Yes.
Reply. ಕಾತರ್ಕನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 39/4 ಮತ್ತು 39 ಜಮೀನುಗಳು ಬಡಾವಣೆ ನಿರ್ಮಿಸಲು ಬಿಡಿಎ ಅಭಿಯಂತರ ವಿಭಾಗಕ್ಕೆ ಹಸ್ತಾಂತರಗೊಂಡಿದೆ ಮತ್ತು ಸದರಿ ಜಮೀನುಗಳು ಪದಾಧಿಕಾರಿ ಬಡಾವಣೆ ರಚಿಸಲಾಗಿದೆ. ಕಾತರ್ಕನಹಳ್ಳಿ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 39/4 ಮತ್ತು 39/3 ಜಮೀನುಗಳು ಬಡಾವಣೆ ನಿರ್ಮಿಸಲು ಅಭಿಯಂತರ ವಿಭಾಗಕ್ಕೆ ಹಸ್ತಾಂತರಿಸಲು ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಕಂಡುಬರುತ್ತಿಲ್ಲ. ಬಡಾವಣೆ ರಚಿಸಿದೆ. I am in possession of a small site. This is in this reply.
What is your right, sir?
I have
you might be in possession.
I have purchased the property under Annexure A.
No, correct. But how did you acquire it? If you are in possession, you can only protect possession. The acquisition cannot go.
No, purchase the property under Annexure B. Sale deed is B. Annexure B.
G and
Page
H.
13(1)(3).
What is challenged here?
I say that has not been dispossessed. Till today, I am the owner of the property. No counter is filed.
What is challenge?
Challenge is the acquisition notice. No. Last if I turn to page
G and H. Why don't you appear before the authorities and produce all these documents? It's only.
Kindly turn to page 74. I have appeared. Page 74. I furnished the documents.
But you should have allowed the BDA to decide.
Model.
And you suddenly come to this court.
They do not take decision. I have been appearing before the other Manduna appear 73. I given the
right. Before they could decide, you are before this court.
Let them decide. I will appear any day. Let them decide the matter. I have no
let them decide. Let them decide. Let them decide it.
Yes, with liberty to file my
petitioner has challenged a show cause notice. Challenged show cause notices bearing number so and so, dated so and so, and bearing number so and so, dated so and so. Bracket annexure G and H. Next para. The petitioner contends that he is the owner of a property bearing house list number 260, site number 24, situate in survey number 39/4 of Nehru Road, 39/4 of Kammanalli. Having purchased it in terms of a sale deed dated 6/2/1995. He claims that the property was assessed to municipal property tax and he had obtained electricity connection to the property. He claimed that on 5/3/2019, he claimed that he received a letter, he received a notice from the respondent number 2, dated 5/3/2019, calling upon him to produce documents in respect of the property claimed by him in survey number 39/4. He claimed that he sent a reply informing the respondent number 2 that he had purchased the property measuring 30 into 24 square feet from Chinnappa in terms of a sale deed dated 6/2/1995. Full stop. However, a subsequent notice was issued by the respondent number 2, calling upon the petitioner to appear before him. Full stop. The petitioner claims that that he sent a reply to the respondent number 1, producing therewith certain documents. Full stop. He contends that the respondents 2 and 3, respondents have no right in respect of the property claimed by him, as he had filed and this is evident from the fact that in response to an application filed under the RT Act as to whether the land in survey number 39/3 and 39/4 was acquired and used up for formation of a layout, the respondents had informed that the land in survey number 39/3 and 39/4 was not taken, informed that possession of the land in survey number 39/3 and 39/4 was not taken and no layout was formed. Full stop. The petitioner is therefore before this court challenging the said notices. The learned counsel for the petitioner submitted when the respondents have not taken possession of the land in survey number 39/3 and 39/4 of Kammanalli, and they have not formed any layout, the impugned notices issued by the respondent number 2 is without the authority of law. He, however, contends that the petitioner has replied to the said notices, but no steps are taken to decide the objections raised by the petitioner. The learned counsel for the respondent number 1 and 2 submits that even before the reply of the petitioner could be considered, the petitioner has approached this court, and therefore the respondents have not considered the represented objections. He submits that if reasonable time is granted, the respondent number 2 would consider the objections and pass appropriate orders. Next para. A perusal of the impugned notices would show that they were innocuous in as much as by the said notice, the respondent number 2 called upon the petitioner to furnish documents in support of his claim to the property to a site formed in survey number 39/4 of Kammanalli. Full stop. Therefore, it was incumbent upon the petitioner to have produced those documents and he should have allowed the respondent number 2 to determine the objections. Full stop.
I have produced
The impugned notices are therefore not justiciable. And it is for the petitioner to appear before the respondent number 2 and establish that he has a right to continue in possession of the property. In that view of the matter, this writ petition deserves to be disposed of, directing the respondent number 2 to to consider the objections filed by the petitioner to the show cause notices dated 5/3/2019 and 28/2019 within a period of 3 months from the date of receipt of a copy of this order. In order to enable the respondent number 2 to do so, the petitioner is directed to furnish a fresh copy of the reply dated
15th.
reply dated ಯಾವತ್ತಿದು annexure J date ಏನು
15/3/2019.
26/8/2000
ಅದ
and 15/3/2019 to the respondent number 2.
Let me not be dispossessed till the inquiry is complete.
No. The respondent number 2 shall pass appropriate orders as stated above. Yes.
Serial number 55, Shivramu HC.
HC Shivram.
In this matter, my lords, appearing for respondent, my lords, we have returned the file, my lords, we have given the NOC wakalat.
ಯಾರಿಗೆ?
Ajay Kumar M.
ಹಾ.
We have returned the file to BDA, my lords.
The Honorable Counsel for the respondent submits that he is retired from the case and returned the file to the respondent. Hence list on ಯಾವತ್ತು ಬೇಕು?
Next week, 2 weeks.
2 weeks ಎಲ್ಲ ಕೊಡೋದಿಲ್ಲ.
Next week.
Next Thursday. ಹಾ?
ನಾಗರಾಜರಾವ್ ಅವರು ಆಫೀಸ್ ಕ್ಲೋಸ್ ಮಾಡಿಂದ ಫೈಲ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್.
ಹಾ, ಅದು ಆಗೋಯ್ತಲ್ಲ ಕೇಸು.
ಇವತ್ತುದ ಸರ್ 55
ಹಾ?
38,796 ಸರ್.
53 ಅದು
53 ಆಗೋಯ್ತು, ಅಡ್ಜರ್ಮೆಂಟ್ ಆಯ್ತು.
ನೆಕ್ಸ್ಟ್ ಥರ್ಸ್ಡೇ
ಬರ್ಲಿಲ್ವಲ್ಲ ನೀವು ಯಾರು?
ಸರ್ ಅದು ಬೇರೆ ಅಡ್ವೊಕೇಟ್ ಹಾಕೋಬೇಕು ಅಂತ.
ಅಲ್ರಿ ಕೇಸ್ ಕರೆದಾಗ ಬರ್ದಿಲ್ವಲ್ಲ ಯಾರು?
NOC ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್.
Yes, next.
Serial number 56, Sadanand G Shastri.
To appear for the petitioner in this matter. I have a submission to make, my lord. My colleague, while traveling, she had the file. She met with a small accident, my lord, maybe taken up 1 or 2 days after also. And the respondent have to file their objections also in this.
ಏನಪ್ಪ ಎಲ್ಲ ಹಿಂಗೆ ಮಾಡ್ತೀರ?
Any date may be fixed.
ಅಲ್ಲ, date I will fix. Whether you say it or not, I will fix a date. But the way you lawyers are conducting themselves,
I deeply apologize.
nobody is arguing the matter. List learn counsel for the petitioner seeks time. List on so the same order, ma. List on next Thursday.
Great.
Number 57 urgent. Serial number 58, HN Basuraju.
Appearing for
I appear
respondent.
for the petitioner minutes.
Respondent.
Was allotted a site.
Yes, mister.
Appearing for respondents, your lordship.
Where is he?
So he is engaged in other court, your lordship.
ಕರ್ಕೊಂಬರ್ರಿ.
Any short date may be given.
ಶಾರ್ಟ್ ಡೇಟ್ ಎಲ್ಲ ಕೊಡೋದಿಲ್ಲ. ಒಂದ್ ಕೇಸನ್ನ ಆರ್ಗ್ಯೂ ಮಾಡ್ರಪ್ಪ. At least one case you argue.
But today there are 34 cases listed, your lordship.
ಅಷ್ಟೊಂದು ಯಾಕೆ ಫೈಲ್ ಮಾಡಕ್ ಹೋದ್ರಿ?
Please, any short date, your lordship.
One
Please.
case ಅಲ್ಲಿ ಆರ್ಗ್ಯೂ. No. Yes.
BDA was allotted a site, my lords, in number 1215.
Mister, I am going to record that you are unable to argue. If I decide the case, I will say that you refuse to argue.
That's 1215, the site measuring 3040 minutes allotted by the BDA in the year 1968 minutes. I paid the amount, the cost of rupees I have produced in annexure A. The cost of payment. That's later, my lords, after paying the amount, the BDA has some stranger saying Amarnath was put into the possession. Later, my lords, we approached the BDA saying that the 1215 site was allotted to me. Then the third party, who is Amarnath, is a trespasser, has to be removed from the place. Let's have produced the sale deed of Amarnath, my lords. Let's kindly see annexure A, my lords, page number 21. 21. GA Shivshankar. Niveshana Sanke 1215.
21 is annexure A.
Please, my lords, annexure A.
GA Shivshankar.
Thank you. The petitioner herein paid 1,000 and some odd.
Niveshana Sankhya 1215. It was allotted by the BDA after paying the cost. Later, my lords, Annexure C, the BDA has allotted site to one Muniraju in the year 1989, after 28 years, in the same site, 1215. After we got to know this, we approached the BDA saying that this site was allotted to me in the year 1968. How can you allot the site, the same site, to some other person? That's what the BDA has said, my lords. Let's kindly see page number 55. May I read, my lords? ಅರ್ಜಿದಾರರ ಕೋರಿಕೆಯಂತೆ BDA ಸಂಖ್ಯೆ 1161, the alternative site I have proposed, my lords. 1215 was registered to someone. As it comes under the same vicinity, I approached the BDA to allot the other site, my lords. 1261 bar B. ಎರಡನೇ ಹಂತ ಬ್ಲಾಕ್ ಬಡಾವಣೆ ಆಗಿದ್ದು ಪ್ರಾಧಿಕಾರದ ಸ್ವತ್ತಾಗಿರುತ್ತದೆ. ತೆರವುಗೊಳಿಸಲು ತೆರವು ಪ್ರಕ್ರಿಯೆಗೆ ಹೆಚ್ಚಿನ ಕಾಲಾವಕಾಶ ತೆಗೆದುಕೊಳ್ಳದೆ ಇದ್ದು ಕಾನೂನಿನ ತೊಡಕುಗಳು ಇಲ್ಲದೆ ಇದ್ದು ತೆರವುಗೊಳಿಸಿ ಹಂಚಿಕೆದಾರರ ಹೆಸರಿಗೆ ಸದರಿ ನಿವೇಶನವನ್ನು ನೋಂದಾಯಿಸಿ ದಾಖಲೆಗಳನ್ನು ನೀಡಲು ಸದರಿ ನಿವೇಶನ ಸೂಕ್ತವಾಗಿರುತ್ತದೆ. The BDA has observed this, my lords. Later we approached the.
So you gave up 1215.
Please, my lords.
You gave it up.
We have, my lords, as we don't have any alternative, my lords, remedy. We gave a representation to the BDA stating that there is one more site adjacent to this land, that's 1161 bar B. If BDA has allowed this site, we'll give up the 1215 site. We approach the Honorable High Court. That's in page number 65.
Yes.
This some other petitioner, lords. I'll take your lordship to 88 minutes, page number 88. The operative portion is in 89 minutes. If any site has been recommended for allotment to the petitioner, it shall be kept vacant and shall not be allotted to any other party till the next date of hearing. The learned counsel submits that site number 1161 bar B, measuring 30 so and so, has been recommended for allotment to the petitioner. The same shall be kept vacant till next date of hearing.
In this petition?
My lords,
What was sought for in this petition?
we sought for 1161, my lords, other than 1215.
Petition, what was the reliefs that were sought for?
That's the site 1161 to be kept
that is the interim order, mister. What was the main relief that you sought for in this petition?
That's I'm not aware of, my lords, though.
Can I make one small submission? ನನಗೆ ಒಂದು 2 ದಿನ personal problems ಇತ್ತು ಸ್ವಾಮಿ. ಅದರಿಂದ I was not prepared. Otherwise I am not like this. ನನಗೆ ಒಂದು ಟೈಮ್ ಬೇಕಾಗಿದೆ. In fact, I spoke to a senior. I was under the impression that ಅಲ್ಲ ನಾನು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿ if I do not ಅಲ್ಲ ನಾನು I am the last person.
It is 124, the list is already over, Unni Krishna.
ಗೊತ್ತಾಯ್ತು ಸ್ವಾಮಿ. I'm sorry, I feel
124, the list is over.
ನಾನು in fact I spoken to it. I mentioned it to his nice. ಗೊತ್ತಾಯ್ತು.
Time is 124, then the list is over, exhausted.
That is unfortunate. I'm sorry, my lord. I am
unfortunate.
ಅಲ್ಲ ನಾವು contribute ಮಾಡಿದೀವಿ to such a sad state. ತಾವು ಬೇಕಾದ್ರೆ ಒಂದು ಡೇಟ್ ಫಿಕ್ಸ್ ನಾನು ಮಂಡೇ ಟ್ಯೂಸ್ಡೇ ಎನಿ ಡೇ ಐಲ್ ಗೋ ಆನ್.
ನಾನು ಬೇಕಾದ್ರೆ ನಾನು ಮಾಡೇ ಮಾಡ್ತೀನಿ.
ಆಯ್ತು,
ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡೇ ಮಾಡ್ತೀನಿ.
ಮಾಡಿ ಐ ವಿಲ್ ಗೋ ಆನ್. I understand.
This will not happen from the next week.
Yes, my lord.
Next week you people will have to shell down a lot of money. Counsel for the respondent, number 1 to 3 seeks time. Response Thursday.
There is an interim order, my lords.
Interim order granted. Please come ready, mister.
Please, my lords. In fact,
please come ready. You don't open the file.
That's just 20 minutes back. Adjournment ತಗೊಳ್ತಾರೆ ಅಂತ ನಾನು ತಗೊಂಬಾರ್ದು ಅಂತ ಓದ್ಕೊಂಡ್ ಬಂದೆ 20 minutes back. Please, sorry.
ನೆನ್ನೆ ಓದ್ಲಿಲ್ವಾ?
ಅಲ್ಲ, ನಮ್ ಸೀನಿಯರ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಕೊಟ್ಟಿರ್ಲಿಲ್ಲ ಅಷ್ಟೇ. ಅದಕ್ಕೆ ನಾನು ಈಗ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ತಗೊಂಬಾರ್ದು ಅಂತ ಓದ್ಕೊಂಡ್ ಬಂದೆ.
Yes, next.
I'll read out.
Serial number 59 urgent. Serial number 60 Rakshita DJ.
Same day actually.
Thursday.
This case.
Yes. ಇದು Thursday ನಾ?
15 ನಮ್ದಲ್ಲ ಇದು.
Very short point.
ಅಲ್ಲ,
Short point for your lordship.
ಇದು ಬಂಧನ ಆರ್ಗ್ಯೂ ಮಾಡ್ರಿ ಯಾವ್ದು
ಅಲ್ಲ, ಮಾಡ್ತೀನಿ
By law also.
ನನ್ಗೆ ಅದು
Settled by this court.
Learn counsel for the respondent number 2, 1 and 2 seeks time, list on sounds Thursday.
Serial number 61, Nishant Devi.
Interim order is there.
Interim order extended till the next day.
Obliged by.
61, Nishant Devi.
Vachan,
ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಆಗ್ತೀವಿ, ಸ್ವಲ್ಪ ಟೈಮ್ ಕೊಡಿ. ಬನಶಂಕರಿ 6 ಸ್ಟೇಜ್ ಅಕ್ವಿಸಿಷನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ. ಆಕ್ಚುಲಿ ಅವರು ಇನ್ನ ಅದು 24 ಅಲ್ಲೇ ನಾನು ಗಿವನ್ ದ ಕಾಪಿ ಆಫ್ ದ ಪಿಟಿಷನ್ ಟು ದ ಬಿಡಿ ಅವ್ರು ನಂಗೆ ಇನ್ನ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ, ಪಿಟಿಷನ್ ಕಾಪಿ ವಕಾಲತ್ತು ಕೊಟ್ಟಿಲ್ಲ, ಏನು ಕೊಟ್ಟಿಲ್ಲ. ಹೆಸರು ತೋರಿಸಿದ್ರೆ ಸ್ವಾಮಿ ಅದಕ್ಕೆ.
learn counsel for the respondent number 2 and 3 seeks time. List on
12 June.
2 weeks.
12 June.
Kodi Atum. Yes, next.
18 June. 18 June. Serial number 62, Prakash.
The matter has been assigned to Basuraj.
Prakasham.
Today only I received instructions. Wakalat not yet received.
What's your name?
Basuraj HT.
H?
HT.
HT Basuraj. Office is directed to show the name of Mr. HT Basuraj as a counsel for respondent 2 and 3 after deleting the name of Mr. B. Vachan. And yes, next. List on so and so.
Serial number 63,
2 weeks.
Srinivas Murthy.
I pray for 2 weeks time.
Yavata kodri.
date only short but direction consider the representation.
Next.
18 June. Serial number
Only
63,
consider the representation, madam.
Srinivas Murthy, SR.
Yes, sir, Srinivas Murthy.
They have sought out a copy of the petition only.
Learn counsel for the respondent number. Respondent submits that copy of the writ petition is not furnished to the furnished to him. Hence, full stop. There is no representation for the petitioner. The learned counsel for the petitioner is directed to serve a copy of the writ petition along with all enclosures to the learned counsel for the respondent. Chetan.
Serial number 64, Chetan AC.
Appearing for the petitioner, my lords, we have seeked a representation to grant an alternative site for the BDA.
Yes.
Maybe directed to consider the representation.
Petitioner sought for it in the nature of mandamus to consider his representation dated 26/2/2026 for allotment of an alternate site in Sir M. Vishweshwaraya layout. Next, our petitioner contends that $20.20 guntas. 20.20 guntas ಹೆಂಗಾಗುತ್ತೆ?
20.2 ಇರಬೇಕು.
20.2 ತಾನೇ ಹೆಂಗಾಗುತ್ತೆ?
ಗುಂಟಾಸ್ ನಲ್ಲೂ ಇವಾಗ ನಾವು ದೇ ಆರ್ ಗಿವಿಂಗ್ ದಟ್ ಫರ್ದರ್ ಬ್ರೇಕ್. ಗುಂಟಾ ಇದ್ರೂ ಕೂಡ ದೇ ಆರ್ ಗಿವಿಂಗ್ ದ ಫರ್ದರ್ ಬ್ರೇಕ್ ಡೌನ್ ಇನ್ ಸಮ್ ಆಫ್ ದ ಮ್ಯಾಟರ್ಸ್.
ಕರೆಕ್ಟ್ 20.4, 20.8, 20.12 ಅಂತ ಇರೋದು. ಕಾಲು, ಅರ್ಧ, ಮುಕ್ಕಾಲು. What is this 20.20? Yes, madam.
That's 20, 20, my lords, it is.
ರೆಲಿಂಕ್ವಿಶ್ಮೆಂಟ್ ಡೀಡ್ ಪೇಜ್ 9 ನಲ್ಲಿ ಅದೇ ತರ ಬರೆದಿದ್ದಾರೆ, ಹಾಗಾಗಿದೆ.
20.20 is 21 guntas.
Please.
In relinquishment.
Quarter is 0.4, half is 0.8, 3/4 is 0.12.
16 guntas, 16 ಬಂದ ತಕ್ಷಣಕ್ಕೆ it should have.
Petitioner claims that a portion of land belonging to him and his brothers situated in various survey numbers of Gollalli were relinquished in favor of the respondent with a relinquishment deed dated 13/6/2013. Following this, the respondent allotted 4 sites to the petitioner and his brothers. As regards the 3 sites, there is no issue, while in respect of the 4th site, bearing number 1107/B in 3rd sector HSR layout, the same lies within the park zone and is not identifiable. The petitioner therefore gave a representation to the respondent number 3 on 26/2/2026, requesting the respondent number 3 to allot a site measuring 50/80 in Sir M. Vishweshwaraya layout. Being agreed by the non-consideration of his representation, the petition is before this court. The Learned Counsel for the petitioner reiterated the above submissions and submitted that a direction be issued to the respondent, number 3, to consider the representation. The Learned Counsel for the respondent, on the other hand, submitted that the petitioner has hastily approached this court even before the respondent, number 3, could consider the representation. He, however, submits that if reasonable time is granted, the respondent, number 3, would consider the representation. Next, in view of the fact that the petitioner was granted a site by the respondent which purportedly is not identifiable, the respondent, number 3, is bound to consider the representation of the petitioner and pass appropriate orders. In that way of the matter, the petition is allowed. The respondent, number 3, is directed to consider the representation of petitioners dated 26/2/2026 for allotment of an alternate site measuring 50 by 80 in Saryam Vishweshwara layout within a period of 3 months from the date of receipt of a copy of this order.
Good.
Serial number 10, interim order may be extended. Serial number 10, we missed to extend the interim order. Interim order may be kindly extended.
Till the next date.
61, my lords.
Much
My
better.
apologies, my lords. I was on my legs. There's an
60?
interim order. 61, my lords. My apologies, my lords. I could not appear. There's an
Ishan.
interim order. Please,
Ah.
my lords. I was on my legs. My humble
Interim
apologies.
order is extended till the next date of it.
My lord, serial number 59, my lord, they are no, and they won't inform me on other side also, my lord, and we have filed our statement of objection repeatedly, they're telling that they'll file application for, to give a rejoinder to my objection, my lord, they'll keep on taking time, my lord. But today I am ready also, my lord.
Next week, it is listed next week.
Obliged.
My lordship, serial number 34, my lordship.
So next week I will be very strict.
Yes, my lord.
First week, vacation in the people will be gone abroad, they'll come. So I'm liberal. From next week, I'll wield the, yes.
Serial number 34, my lordship. Kindly
Serial
place some
number?
34, my lordship.
What do you want?
Kindly place some short accommodation, my lordship. I was in the court all 10, my lordship.
It is passed over, madam.
Yes,
You got it passed over, then
no,
please
my
come.
lordship. I was engaged in court of 10.
Please come at 2:30. Start date would be.
Number 1 ಇತ್ತಲ್ಲ, ಇವ್ರು ಸರಿ number 10 entry ಮಾಡ್ಬೇಕು. ಮಾಡ್ತೀರಾ? ಅಲ್ಲ ಮತ್ತೆ ನೀವು ವೈಟ್ನರ್ ಹಾಕಿದ ಪ್ರಯೋಜನ ಏನು ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ಗೆ? ಕರ್ಕೊಂಬಂದು ಹಾಕ್ಸಿ ಅಂತ ಹೇಳಿರೋದು ಸಾಹೇಬ್ರು. ಬರ್ಲಿ ಪಾಸ್ವರ್ಡ್ ಹಾಕಿದ್ರೆ ಆಫೀಸ್ ಅವರು ಸುಮ್ಮನೆ ರಾಂಗ್ ಜೈಸ್ ಮಾಡೋರು ಅಂತ ಆಗತ್ತೆ ರೀ.
ಸರ್ ಪಾಸ್ ಓವರ್ ಎಷ್ಟಾಗಿದೆ?
7 ಪಾಸ್ ಓವರ್ ಇರೋದು ಸರ್, ಲಿಸ್ಟ್ ಕ್ಲೋಸ್.
59 ಏನು ಸರ್? 59.
12/6.
ಪಾಸ್ ಓವರ್ ಎಷ್ಟಾಗಿದೆ?
your lordship's permission,
Ah,
serial number 63, I may permitted to serve the copy on the council for BDA.
ah,
By the time I was here, it has been collapse ಆಗಿತ್ತು. ಪಕ್ಕದ ಓಡ್ ಬರೋಷ್ಟಾಗ ಮ್ಯಾಟ್ has been called and no representation ಅಂತ ಆಗಿತ್ತು.
ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ?
ಅಲ್ಲ, I may permitted to serve the copy on the council.
ಸರ್ವ್ ಮಾಡಿ.
ನೆಕ್ಸ್ಟ್ ಒಂದು ಡೇಟ್ ಕೊಟ್ಬಿಟ್ರೆ.
ನೆಕ್ಸ್ಟ್ ವೀಕೆ ಕೊಟ್ಟಿದೆ ಅನ್ಸುತ್ತೆ. ಯಾವತ್ತೋ ಕೊಟ್ಟಿದೆ ನೋಡಿ, ಶಾರ್ಟ್ ಡೇಟೇ ಕೊಟ್ಟಿದೆ. ಕಾಪಿ ಸರ್ವ್ ಮಾಡ್ಬಿಡಿ.
ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿ.
ಸರ್ವ್ ಮಾಡಿ ಮೂವ್ ಮಾಡಿ.
ಆಯ್ತು.
First door matter, serial number 1, Sumana Naganand.
Appear for the petitioner. Needful is done, my lord. We have complied with the office objection.
Counsel for the petition submits that the office objections are complete. Office is ready to check and verify. ಫೈಲೇ ಕೊಟ್ಟಿಲ್ವಾ?
ತಗೊಂಡು ಮಾಡ್ಕೊಟ್ರು ಅಂತ ಹೇಳಿದ್ರು. ನಾನು
ಫೈಲೇ ಕೊಟ್ಟಿಲ್ವ ಅಂತ ಇವರು
ಮಾಡಿದ್ರು ಅಂತ ಹೇಳಿದ್ರು ಸರ್.
ಇಲ್ಲ, counsel for the petitioner seeks time to comply the office. 1 week time is granted to do the needful.
Much obliged. Sorry for the miscommunication.
Serial number 4, Dinesh Gonkar. Serial number 4.
There is no representation for the petitioner, though it is called twice in the day. No steps are taken to serve the respondent number 2 and 3. The petition is dismissed for non-prosecution.
Serial number 20,
G. Bhargav.
Bhargav ji.
I'm appealing for petitioner.
ಓದಿ. ಫೈಲ್ ಓದಿದ್ರಾ? ಓದಿ.
ಆಮೇಲೆ ಕೃಷ್ಣಮೂರ್ತಿ ಅದ ಪ್ರಾಪರ್ಟಿ ಓನರ್ ಮೇಲೆ
ಕೃಷ್ಣಮೂರ್ತಿ ಅವ್ರದ್ದು
ಅಬ್ಸಲ್ಯೂಟ್ ಪ್ರಾಪರ್ಟಿ ಓನರ್ ಮೇಲೆ
ಹಾ
ಸೈಟ್ ಓನರ್ ಅವರಿಂದ ಲಕ್ಷ್ಮಮ್ಮ ಅವ್ರು ಪರ್ಚೇಸ್ ಮಾಡಿದ್ದಾರೆ ಮೇಲೆ ಪರ್ಚೇಸ್ ಮಾಡಿ ಅವರು ಡೆತ್ ಆದ್ಮೇಲೆ ಸೇಲ್ ಡಿಡ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಂದ್ರೆ ಬಿಡಿಎದವ್ರು ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ತಿಲ್ಲ ಮೇಲೆ ನೋಡಿ, ಅದಕ್ಕೆ ಇಶ್ಯೂ ನೋಟಿಸ್.
ಹಂಗೆ ಸುಮ್ಮನೆ ಇಶ್ಯೂ ನೋಟಿಸ್ ಅಲ್ಲ, ಇದೇ ಸರ್ಚ್ ಏನು ಕೇಳ್ತಿದ್ದೀರಾ? ಸೆಟಿಸೈಡ್ ಮಾಡಿ ಅಂತ ಕೇಳ್ತಿದ್ದೀರಾ? ಯಾರು ಸೇಲ್ ಡೀಡ್ ಇದು ಸೆಟಿಸೈಡ್ ಮಾಡಬೇಕಾಗಿರೋದು? ಪ್ಲೀಸ್ ರೀಡ್ ದ ಪ್ರೇಯರ್ ಓದಿ.
Of annexure A has been sale deed dated 4/12/1973 registered unilaterally in this name of P.R. Krishnamurthy registered on 3/1/1974 in respect of residential property bearing number 4229 new municipal number 9 situated of Rajaji Nagara so and so measuring issue writ mandamus of any other restriction BDA of the sale deed in favor of legal registration. My 2 days time.
ಈ ಸೇಲ್ ಡೀಡ್ ಹೆಂಗಮ್ಮ ಸೆಟಿಸೈಡ್ ಮಾಡಕ್ ಬರುತ್ತೆ ಇಷ್ಟು ದಿನ ಆದ್ಮೇಲೆ? 74ನೇ ಇಸ್ವಿ ಸೇಲ್ ಡೀಡ್ ನ ಸೆಟಿಸೈಡ್ ಮಾಡಿ ಅಂತ ಕೇಳ್ತಿದ್ದೀರಾ? ಯಾರು ಕೊಡ್ರಿ? Mr. So-and-so is directed to accept notice for respondent. ಅಷ್ಟೇನಾ ಆಗೋಯ್ತಾ?
Serial number 34.
ಕಾರ್ತಿಕ್ ವಿ
34 Karthik V.
NR Girish.
Appearing for the petitioner, my lordship. Kindly place some short accommodation, my
How
lordship.
much cost will you pay, madam?
Senior is not well, my lordship.
Not well. He has not come to the court.
No, my
Are you sure?
Yes, sir.
Can I get it verified? No, I'll get it verified. You got it passed over in the morning.
No, my lordship. I was engaged in court till 10, my
Learned
lordship.
counsel for the petitioner seeks time. So and so, same order, madam. No adjournment, huh? List on next Thursday.
11 June. Serial number 49. Hanumantraya D.
D. Hanumantraya.
Do charity for
Murugesh
respondent.
Sharati. Murugesh Sharati. This 50 lakhs.
Yes, madam. Morning they were argued.
Phone ಕರೀರಿ ಎಲ್ಲಿದ್ರು ಕೇಳ್ರಿ ಅವ್ರು. Find out where he is. ಇದು ಎರಡು ಕೇಸ್ ಬಿಟ್ರೆ ನಮ್ದು ಲಿಸ್ಟೇ ಆಗೋಯ್ತು.
The committee.
ಏನಂದ್ರೆ ಅದೇ ಆಶಾ ಭಾವನೆಯಲ್ಲಿ ಇದ್ದೀನಿ.
The committee was already decided at page number 42, madam.
ಆಯ್ತು ರೀ, ಇಲ್ಲಿ ಅವ್ರು ಬಂದ್ರೆ ಮುಗಿಸೋಣ ಅಂತ ಹೇಳಿದ್ರು. Yes, please. ಅಲ್ಲ ಮೇಡಮ್, it's a 30-40 site. 6 lakhs is already paid. Now you are demanding 54 lakhs. Huh? ಆಯ್ತು, even if ಏನ್ ಫ್ರಾಡು ಓದ್ ಏನ್ ಹೇಳ್ತೀವಿ ಓದ್. ಪ್ರಾಧಿಕಾರದ ಉಪಕಾರ್ಯದರ್ಶಿ ವಿಭಾಗದ ಶ್ರೀಮತಿ ಮಹಾದೇವಮ್ಮ ಮತ್ತು ಎರಡನೇ ಮುನಿ ಚಚ್ಚೇಗೌಡರ ಕೆಳಕಂಡ ಆರ್ಥಿಕಪಡಿಸಿಕೊಳ್ಳದೆ ನೇರವಾಗಿ ಶುದ್ಧ ಕ್ರಯ ಪತ್ರ ನೋಂದಾಯಿಸಿ ಸ್ವಾಧೀನ ಪತ್ರ ನೀಡಿ No, please tell me 30/40 site. 6 lakhs is already paid. Now you are demanding 54 lakhs, which is totally 60 lakhs. So from when did BDA charge 5,000 rupees per square feet? Allotment price 5,000 ರೂಪಾಯಿ ಯಾವಾಗಿಂದ ಮಾಡಿದ್ದಾರೆ? $54 lakhs. ಅಷ್ಟೇ ಬಂತಲ್ಲ, 54,000 per square meter ಅಷ್ಟೇ ಆಯ್ತಲ್ಲ. Madam, incentive site ane, yes, Murugesh has come. Yes, Mukesh. Huh? Now the sale deed is executing, everything is done and dusted. Then how can you lay a demand from them? You recover it from your officers who are responsible. Sale deed is already executed, money is already received, possession given. How can you now raise a demand after so many years? Ah. Yes. Yes.
Asked him to pay certain amount. That was not the actual value at which it should have been allotted. What thereafter it was noticed that the site is allotted at a very lesser price. He is not a regular allotment. He is the person who had lost his land, to which incentive site has been allotted. Not see, incentive site is at a allotment price. It will be at a allotment rate. What has happened is he gives the chance of not waiting for several years.
ಎಷ್ಟು ಅಲಾಟ್ಮೆಂಟ್ ಪ್ರೈಸ್ ಎಷ್ಟಿತ್ತು ಅವಾಗ?
54,73,600 rupees he has to pay towards the value of the site.
ಎಷ್ಟು ಸ್ಕ್ವೇರ್ ಫೀಟ್ ಆಯ್ತು ಅಲ್ಲಿಗೆ?
30 to 40 is
1200 divided by 10.8, 3.26 into 3.26 is equal to 10.62. ಎಷ್ಟಾಯ್ತು? 112. 112 ಚದರ ಮೀಟರ್ ಇಂಟು 50.
54,500.
ಹಾ.
60,75,600.
ಹಾ. ಅಲ್ಲ ನೀವು ಹೇಳ್ತೀರ 5,000 ರೂಪಾಯಿ ಹೆಂಗ್ ಫಿಕ್ಸ್ ಮಾಡಿದ್ರಿ ಅಂತ? 54,000 per square meter, which it will come to 5,000 rupees per square feet. 5,000 rupees allotment price ಯಾವಾಗಿಂದ ಫಿಕ್ಸ್ ಮಾಡಿದ್ರಿ? Don't go by the guidance value. ನಿಮ್ಮ allotment price ಎಷ್ಟು?
In 2017, when it intermediately signed remain, you will allotment as an incentive site as allotment then we take that as on that day rate because it is a sale, outright sale.
Anyway, then
the incentive site routes it will be an outright sale.
ಹೌದು.
Outright sale of I will not be in a position to give for a lesser price. What if he pays an allotting? But he waits for 10 years to get his seniority. Then he gets it at a lesser price where we give it at a 50% guidance value. Now it is stopped now, that also is stopped. 60% of the guidance value that we give it to them. And not he constructs the house for 10 long years.
No.
Here not it will be an outright sale.
That is an incentive site.
Yes.
Incentive ಮತ್ತೆ ಇನ್ನೇನ್ ಬಂತು?
Incentive ನಾವು ಇದನ್ನ ಕೊಟ್ಟಿರ್ತೀವಿ. Award amount ಎಲ್ಲ ಕೊಟ್ಟಿರ್ತೀವಿ.
Yes.
It is not in 40-60 ratio site. It is incentive site is only with regard to avoid that 10 years of waiting.
Correct. Waiting ಅಂದ್ರೆ allotment price ನೀವು ಕೊಡ್ಬೇಕು, ತಗೋಬೇಕಲ್ಲ. Allotment price ತಗೋಬೇಕು. ನೀವು ಗೈಡೆನ್ಸ್ ವ್ಯಾಲ್ಯೂ ತಗೊಳಂಗಿದ್ರೆ why should you purchase it from you? You can purchase it in the open market. Huh? No. ಎಲ್ಲಿದೆ ಇನ್ಸೆಂಟಿವ್ ರೂಲ್ಸ್ ಎಲ್ಲಿದೆ ಅದು? ಇವಾಗ ನಾನು ಬೆಳಿಗ್ಗೆ ನೋಡಿದ್ನಲ್ಲ.
ಪೇಜ್ ನಂಬರ್ 460.
ಈ book ಅಲ್ಲ?
463. Rules status. The relevant.
Please read how the rate is fixed. Payment of cital value.
Value fixed by the authority.
Shall also be liable to pay any other charges which the authority may levy in this behalf from time to time. Then note you are kindly see note 7, rule 7. Payment of the full cital value. Commissioner shall, at the request of the authority, execute the deed of conveyance form subject to the restrictions, conditions and limitations. The site shall be used for residential purposes for any time. Then D, no permission from the authority shall be necessary for alienation of the site as long as it continues to be used for the same purpose for which it was originally allowed. He gets an immediate chance of selling it.
Yes.
General authority will not get the chance of selling the site. He'll have to construct, wait for 10 years, then get permission to sell. Get the sale deed executed only after construction. Here he gets to sell the site.
Yes.
Normally the guidance value, BDS will more than guidance value. But the fact that
Even now that you have already executed the sale deed, where's the question of now making a claim? Sale deed execute ಮಾಡಿ ಆಗೋಗಿದೆಯಲ್ಲ. Then take action against the concerned, recover all the losses against the concern, from the concern. I'll write that in the order. Barkul. No. Once sale deed is executed, everything comes to an end. The petitioner has challenged the correctness of an order, correctness of
endorsement,
an order of an endorsement dated 22/4/2019, passed by the respondent, demanding a sum of rupees 54,73,600 as the balance cital value. Next paragraph. Petitioner contends that she was the owner of a property bearing survey number 1 measuring 10 guntas and survey number 18 measuring 30 guntas, situate in Konadasapura, Bengaluru East Taluk. The aforesaid land was proposed for acquisition in terms of a preliminary notification dated 12/12/1991, followed by a final notification dated 24/1/1996 for formation of a wholesale steel market. Full stop. An award was approved on 2/11/1996, and the possession of the lands were handed over to the engineering department of the respondent on 9/11/1997. Full stop. The compensation amount was deposited by the respondent before the City Civil Court on 3/6/1997. And a sum of rupees 4,73,836 was paid by the respondent to the petitioner. The petitioner has accepted the award and voluntarily surrendered the land belonging to her for public purpose. full stop. She contends that as per the BDA incentive scheme for voluntary surrender of land bracket close rules 1989, the respondent had passed a resolution dated 24/10/2011 to allot sites to the owners who had voluntarily surrendered their land. Full stop. Accordingly, according to the said resolution, an owner is entitled for a site measuring 40 by 60 per acre, subject to a maximum of 10 sites. Full stop. Since the land belonging to the petitioner was 1 acre, she was entitled to allotment of a site measuring 30 feet into 40 feet. Pursuant to the aforesaid resolution, the respondent issued an allotment letter dated 7/9/2018 allotting site number 448 in 11th block, Nagarbavi second stage at a sum of rupees 6,04,960. The petitioner had paid the said amount, following which a sale deed was executed by the respondent conveying site number 448. Full stop. The petitioner contends that long after the execution of the sale deed, the respondent had issued an endorsement dated 22/4/2019 demanding a sum of rupees 54,73,600 as a balance title value. The petitioner is therefore before this court challenging the said order. The learned counsel for the petitioner submitted that under the incentive scheme rules 1989, the petitioner had paid the price fixed, the price of allotment fixed, consequent to which a sale deed was executed by the respondent. Therefore, he contends that the respondent cannot now turn around and claim that the full title value was not paid and that the petitioner is bound to pay a sum of rupees 54,73,600. Full stop. The learned counsel invited the attention of the court to the rules 1989 and submitted that allotment to a land loser who voluntarily surrenders land is by way of an outright sale, and hence the respondent cannot now raise any claim. Full stop. He therefore prays that the impugned endorsement be set at naught. Per contra, the learned counsel for the respondent, objection Aquila, orally submitted that the petitioner orally submitted that the concerned concerned supervisor and STA, second division assistant in the office of the Deputy Secretary -3 had processed the file of the petitioner for allotment of an incentive site without ascertaining the rate at which, without ascertaining the allotment price, and were thereafter instrumental in getting a sale deed executed in favor of the petitioner. He submits that in respect of sites allotted in Nagarbavi, second stage, the allotment price is fixed at a sum of rupees 54,000. 54,000. 54,500 per square meter, while what is collected from the petitioner is only a sum of rupees 6 lakhs 4,960. He therefore contends that the impugned demand is made calling upon the petitioner to pay the balance price. Full stop. He contends when the petitioner is entitled to, he contends that when the respondent is entitled to the value of the site, comma, the petitioner cannot escape from her liability to pay the price. Full stop. He therefore prays that the petition be dismissed and the petitioner be directed to pay the said sum of rupees 54,73,600. Next para. I have considered submissions also. The fact that the petitioner had voluntarily surrendered her land for the purpose of wholesale steel market, comma, is not in dispute. It is also not in dispute that the petitioner was entitled to allotment of an incentive site under the PDA bracket incentive scheme for voluntary surrender of land bracket close rules 1989. Full stop. As per this scheme, any person who had lost land which was more than half an acre and less than 1 acre is entitled to be granted a site measuring 30 feet into 40 feet. Full stop. Under Rule 4 of the Rules 1989, the allottee is bound to pay the value of the site fixed by the authority and also be liable to pay any other charges which the authority may levy in this behalf from time to time. The allotment is to be made on outright sale basis, and it is the allottee who is bound to meet the expenses of registration. Full stop. A perusal of the sale deed executed in favor of the petitioner would go to show that the same was executed by the Deputy Secretary -3 of the Bangalore of the respondent, and the sale consideration mentioned therein is a sum of rupees 6,04,960. Allotment letter ಇದೆಯಾ?
ಇದೆ ಸರ್. ಇದೆ.
ಎಲ್ಲಿದೆ?
At page number 44, annexure D, my lords.
ಏನು ಮಾಡಬೇಕಾಯ್ತು? Even the letter of allotment dated 7/9/2018, 2018. The allotment price is fixed at a sum of rupees 6,04,960. Full stop. Therefore, it cannot now lie in the mouth of the respondent that the petitioner was bound to pay more than a sum of rupees 6,04,960 towards the allotment. Full stop. Having regard to the fact that the respondent has already executed a sale deed and conveyed the property in question to the petitioner, the right, if any, of the respondent to demand higher consideration. The right ಏನಂತಾಯ್ತು? Stood extinguished. Full stop. The transaction between the petitioner and the respondent is concluded, and the respondent cannot lay any claim for any balance title value. If the officials of the respondent are responsible for this, are responsible in causing loss to the respondent, the respondent is bound to proceed against the concerned officials and recover the same from the said officials. This, however, does not justify the respondent in making a demand against the petitioner. In that view of the matter, the impugned endorsement issued by the respondent, bearing number so and so, dated 22/4/2019, is quashed. Allowed in view of the above, the writ petition is allowed, quashed. Full stop. Yes. Next matter also same.
Site number.
Site number change. They are quashed.
Demand.
ಅದರಲ್ಲಿ ಅಲಾಟ್ಮೆಂಟ್ ಲೆಟರ್ ಹಾಕಿದ್ದೀರಾ? ಸೇಮ್ ಆರ್ಡರ್.
Serial number 51.
Appearing for the petitioner, my lord. My lord,
Yes.
the amendment has
If you
been
amended-
carried out in the court file, my lords, and the copies
Learned
are being
counsel for the
filed.
petitioner has amended. Learned counsel for the petitioner has amended the cause title and has also filed an amended cause title. Office director to check and verify. List the petition for on ಯಾವತ್ತು ಬೇಕು? Next Thursday.
Yes, my lord. Please, my lord.
It is made clear no adjournment shall be granted on the next day, next
Please,
date
my
of
lord.
hearing. Yes.
Yes, my lord.
ಹೇಳಿ ಸೇಮಾ? ಈ ತರ ಆದ್ರೆ ಏನ್ ಮಾಡೋದು? ಫಸ್ಟ್ ಡೇ 1:30ಗೆ ಮುಗಿದೋಯ್ತು. ಫಸ್ಟ್ ಡೇ 1:30, ನಿನ್ನೆ 4 ಗಂಟೆ, ಇವತ್ತು 3 ಗಂಟೆ. ಬಟ್ ಏನ್ ಮಾಡೋದು? ಯಾರು ಬರ್ತಾ ಇಲ್ಲಲ್ಲ. From next week onwards I will be strict. ಅಲ್ಲ, ನಾನು ಅಕ್ವಿಸಿಷನ್ ಮ್ಯಾಟರ್ಸ್ 80 ಹಾಕಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀನಿ, 80 ಹಾಕಿ ಅಂತ. ನೆನ್ನೆನೂ 80 ಇತ್ತು, ನೆನ್ನೆ 4 ಗಂಟೆಗೆ ಎದ್ದೋದೆ. ನೆನ್ನೆ 80 4 ಗಂಟೆಗೆ ಎದ್ದೋದು. ಅದಕ್ಕೆ ಫಸ್ಟ್ ವೀಕ್ ಐ ಥಿಂಕ್ ಅದೇ ವಿಡ್ರಾಲ್ ಸಿಂಪ್ಟಮ್ಸ್. ಅದಕ್ಕೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಇಂದ ಪ್ಲೀಸ್ ಡೋಂಟ್ ಮೈಂಡ್ ಇಫ್ ಐ ಎಮ್ ಎ ಬಿಟ್ ಹಾರ್ಶ್. ಅಡ್ಜರ್ಮೆಂಟ್ ಅಲ್ಲಿ BDAಗೂ ಅಷ್ಟೇ, ನಿಮಗೂ ಅಷ್ಟೇನೆ. ಐ ವಿಲ್ ಬಿ ವೆರಿ ಹಾರ್ಶ್.